Okay. Good morning, everyone. Welcome to the Committee on Professional Responsibility and Conduct. And as a reminder, this meeting is being recorded. So Angela, can you take the roll?
Yes. Emil Ali.
Present.
Raquel Brigham-Brown. Raquel, I see you, so. Novella Coleman.
You're saying present. We can't hear you though, Raquel.
Novella Coleman.
Here.
Cassidy Shivers.
Here.
Mary Grace Guzman.
Mm.
Brandon Krieger.
What's happening?
Eleanor Mercado.
Here.
Nima Mohebi.
Present.
William Munoz.
Here.
Daniel O'Reilly.
Here.
Akita Poindexter. Topeka Ravi.
Here.
And Carrie Riley.
Here.
Thank you.
Okay. And I see Mary Grace is here.
Mary Grace, thank you.
Okay, so now we are going on to public comment. So Angela, is there any public comments?
Okay, for anybody that wants to give a public comment, please use the raise hand function at this time. You'll be given 3 minutes to speak. If you're participating by phone, you can press the star key and then number 9. Is there anybody who would like to give a public comment at this time? Please use the raise hand function. I don't see any public comments.
Okay, that's quick. Okay, so next is approval of the minutes from the last meeting. Are there any corrections or modifications to the open session minutes? No. Okay, then if there are no corrections or modifications, may I have a motion and a second?
I'll make a motion to approve the minutes.
Second.
Okay, Angela, please call the roll.
Okay, Ali,
Yes.
Brown.
Yes. Can you hear me?
Yes, I can.
Thank
Coleman,
you. Yes.
Guzman,
Yes.
Mercado,
Yes.
Mohebi,
Yes.
Munoz,
I'll abstain.
O'Reilly,
Yes.
Poindexter, Ravi,
Yes.
Riley,
Yes.
and Shivers.
Yes.
All right, so those are 10 yeses and 1 abstain. The motion carries.
Great. Okay, next on the agenda is my chair report. We have an introduction of a new member because Elizabeth Bradley is now Judge Bradley at the LA County Superior Court. So I'd like to introduce Nima Mohebi. Am I pronouncing that properly?
You pronounced it perfectly, actually. So
Great.
great work.
So do you want, I don't want you to waste your voice, but why don't you introduce yourself and give us a little bit of your background?
Sure. Well, it's great to be here. I'm a commercial litigation partner at Sidley Austin in Los Angeles. I was previously a litigation partner at Latham & Watkins for all of my career. So I've been at Sidley for about a month, so not too long. It's a recent move. I was fortunate enough to work with the committee in connection with the AI guidelines in I guess it was 23. I've been a member of the LA County Bar Association Executive Committee for the last 3 or 4 years, and a member of my former firm's several local committees there as well. So I really appreciate the opportunity to pitch in and help here, and look forward to working with everybody.
Thanks, Nima. We look forward to working with you too, and especially with all of your tech background. It was really helpful having you on helping us with the AI guidelines. So I'm looking forward to your contributions this year and next 3 years, I guess. Okay, so now the staff report. I think Erica, right?
I will be fairly brief. I just wanted to give a brief kind of status update on a few things. So hopefully you all received notification that the succession planning opinion, which is now opinion 2024-209, was adopted by the Board of Trustees to be published, as well as the colleague impairment changes to that opinion, which is still opinion 2021-206. It does have an editor's note indicating what was changed in the opinion when approved by the board in November. So those are posted on the State Bar's website on our opinions section and available for everyone. I am guessing as part of our planning session this afternoon, we will talk about kind of what's next as it relates to succession planning, and hopefully talking about perhaps some further guidance for attorneys as to how to actually effectuate the guidance that is in that succession planning opinion. And then one other quick update at our October meeting, the committee voted to issue opinion 20-0003, which is the flat fees and termination opinion, out for a 60-day public comment. That opinion is out for public comment right now. It is going to, the public comment period ends on January 13th. We've received 2 public comments to date. They are pretty succinct. We will be distributing those to the working group, and then we will also send along anything else that comes in kind of as they come into the working group. We address those public comments at our meeting on January 31st. And then the only other 2 things to talk about are one, civility, just an update. The update is frankly that there is no update. So we should hopefully be hearing something sometime soon, but nothing yet. And then we did have a request at our last meeting to have a little bit of information conveyed about the appointments process, particularly focused on how the appointments process works for officers of the committee. So if you'll indulge me for a minute, I'm going to share my screen and walk through a few slides. These slides are also posted as part of the agenda materials that are accessible through the State Bar website. So you can take a look at them as well, or we can distribute them after the meeting. So if you'll bear with me for 1 second, my PowerPoint is tricky on me. Here we go. It's 20 minutes later. All right, hopefully you can all see my screen. Can everyone see it?
Yep.
All right, so just very high level. So just a reminder of what COPRAC actually looks like. So we have 13 members on the committee, including a chair, a vice chair, and our advisor, who is a non-voting member of the committee. This committee is different from most of the committees at the State Bar because this is a committee that is fully appointed by the Board of Trustees. And just a little recap of what 2024 appointments looked like. So typically the application window has been about 90 days or so. So last year it was in fact exactly 90 days from January 16th through April 16th. The appointments were approved at the July Board of Trustees meeting. Just for a little more context, we did have interviews with several of the preferred candidates. But there's a lot of outreach that's done. And so I wanted to share this just to kind of give you more information about what the appointments process looks like from our appointments team. So this is handled by a different office within the State Bar, but they do a lot of outreach. And so these are a couple of the many organizations that they do reach out to, as well as, you know, as many of you know, State Bar staff will reach out to certain individuals as well, who have either, you know, been active in legal ethics, or we've been hearing from in public comment and so forth as well. But I think this is a good thing to take a look at, and we can come back to this as far as once we start the recruitment process for COPRAC for the 2026 appointment, or I'm sorry, 2025 appointment process, if there's any groups or entities that we should be reaching out to that are missed in this group. So last year we did receive 177 applications statewide for several of our committees, including 141 from attorneys and 10 from current or formal judicial officers, primarily applying to Jenny, which is the Judicial Nominee Evaluation Committee, and 26 from non-attorney public members. For COPRAC last year, there were 4 committee member vacancies, including one based on the elevation of a now former member to the vice chair position. And we received 39 applications, 4 were from public members, so non-attorneys. And the count here is wrong, but 35 were from attorney applicants, including current and formal judicial officers. We received 4 letters of interest for the officer positions, and those are required. So we'll get into that in just a moment, but we received 2 for the vice chair position, 1 for chair and 1 for advisor. For this year, what we're looking at is the application window is going to start just a little bit earlier this year because the Board of Trustees is going to start meeting on a quarterly basis as opposed to about every other month, which is what they currently had been doing. And so the appointments are going to be approved at the May meeting as opposed to the July meeting, which just kind of expedites the timeline on the front end. So that application window is anticipated to open on January 3rd. Ending on March 10th this year. And then I want to talk about a little bit about what the officers' roles are with COPRAC. So the chair's duties are to preside over committee meetings, facilitate the decision-making by the committee, kind of consensus building to the extent we can. Sometimes that's more challenging than other times. I'm thinking about the conversion clause opinion here. Encourage the on the committee, participate in at CLE, so continuing legal education on behalf of COPRAC, including leading the annual ethics symposium. So all of the officers are typically the ones that participate in the recent developments panel. That is usually the first panel of the day at the symposium that focuses on any new opinions that were issued by COPRAC, as well as any opinions by other committees and relevant cases that should be looked at for that past year. The chair typically serves as a lead drafter or advisor for most of the opinions. So either as a lead drafter for quite a few of them, and then otherwise as an advisor. And then they perform other duties if directed by the Board of Trustees. And then the vice chair acts in the absence of the chair, serves as a lead drafter or advisor for opinions as well. And then the advisor provides continuity across the committee. So this is a position that has kind of existed at the committee and gone away at different periods. But we did request that the COPRAC continue to have an advisor back in 2021, and we've had one since then. And that's really because it's helpful to have kind of the institutional knowledge. As you know, these opinions take quite some time, and it is helpful for a committee member who has perhaps been around since 2019 to still be on the committee, because that's when perhaps an opinion was started, and to remind the committee of perhaps an issue has already been discussed and we've moved on from it, and if it's important to revisit it. And then, of course, they also serve as a lead drafter and advisor for opinions as well. So the officer selection process, how that works is each of these officers are appointed by the Board of Trustees for 1-year terms. And typically they start in October, and that's going to likely continue to be the case. Typically there's a succession process here. So the vice chair is typically elevated to the chair position, and the chair is then elevated to the advisor position, and the advisor leaves the anyone who is interested in serving as vice chair can submit a letter of interest and resume to COPRAC staff once the appointment cycle opens. So again, likely in early January. And applicants are going to be interviewed by the Board of Trustees appointments liaisons, which is the chair of the board, Brandon Stallings, and Patricia Barahona. And so this is a new process. So in the past, applicants for the officer positions haven't always been interviewed, but the board for 2025 is going to be interviewing anyone who does apply for chair for an officer position. I'll just add that applying to become officer typically in the past has been those committee members who are either in their farther along in their COPRAC season of life. Typically that's because those committee members have you shorten your ability to participate in the committee essentially. So if you apply after your first year of committee membership, then you'll have essentially 3 more years on the committee. Whereas if you apply after your 3rd or 4th year of COPRAC membership, it extends your time with the committee. And so that's just something to consider if you're considering applying. So as far as what comes next, other than me answering questions, we will certainly let everyone know once the application process does open, in hopes that you will contact anyone who you think should apply to be a part of the committee, as well as if you're interested in applying to become a vice chair, essentially, of the committee.
And if people know of somebody that might think would be a good candidate, should they send them to you or to the other folks, or who?
You can send them to the application for the committees. It's a general application, and you can indicate if you'd like to apply for one or more committees. So some people just apply for COPRAC, some apply for several committees and indicate their preference. But yes, if you're going to directly suggest somebody, just let me know, because you know, obviously it's helpful to get people that are referred to us because they know of their experience in legal ethics or otherwise. Frankly, we really like having a well-rounded committee that can bring a variety of perspectives, not just necessarily, you know, attorney ethics.
Have we ever had a judge on COPRAC? A current judge? Is that possible?
It is possible. There's nothing that prohibits it from the committee side.
Yeah.
Official ethics side of it could, only because they can't, you know, weigh in on anything that could come before them in any way, shape, or form. That's less likely, except perhaps in the instance of like a malpractice case. But to my knowledge, I'm not aware of us having an active judge. I believe we've had ALJs before though, but I could check here. Any questions I can answer on this? If you do have any questions, just as it relates to perhaps applying to become vice chair, or just around the application process and appointments process more generally, don't hesitate to reach out to me or to Angela. We can certainly answer any questions.
Or me or Dan, because we've gone through the process as well. So if you have any questions, go ahead, Raquel.
I was just reminded of what you were saying. Just to say, from your experience, Dan, you're just starting, but Cassidy, you were vice chair before. Maybe any insights? What's the workload between meetings? Just generally, what's behind
Yeah, so I mean, as vice chair, I think that it was more of let's say like a lady in waiting sort of position. So it wasn't a whole lot different than being a regular committee member, but you were, you know, just gradually, at least for me, brought into the leadership position. So the workload wasn't too much, but for the chair position, and then still, it's not you know, a huge lift, because everybody on the committee participates in the drafting and you know, working groups and that sort of thing. But there's a little bit more behind the scenes in organizing the agendas and being a little bit more involved in the opinions. And then the symposium too. I mean, last year I was more involved in the symposium for sure. But that's just me. I mean, that's my experience. Dan or Erica, do you have any insight?
That I've just only gotten started, but I feel like there's a slight increase in planning and agenda setting. But the actual opinion workload is similar so far.
Yeah.
Right.
I'll just add, so thinking that Brandon's not here to speak on this, so I'll pretend to speak on what he knows on it. But I think a lot of it is related more to the opinion work than necessarily like officer specific duties. Staff does try and assist with kind of the prep for the meetings. So we will reach out to you and provide agendas and those types of things for you to review. And we typically sometimes meet before to plan, but not always necessarily. But I will say that typically officers are assigned to a lot more opinions, and that's usually they assign themselves, frankly. But I think Cassidy, Dan, and Brandon, if you look at kind of who's assigned to opinions, they are certainly assigned to more than other committee members.
Right. Yeah, I didn't realize that, but I thought it was just more of an organic volunteer process, you know. But, But so I take it, I guess I take it more seriously now that is actually one of my stated job duties is to serve as lead drafter. So, and yeah, like Dan, I'm just getting started here, so you know things may evolve and change as we move through the year. Okay, are we ready to move on to business? The first item is the discussion of draft opinion 19-0004, client files, release and retention duties. The working group is Mary Grace, Brandon, Eleanor, Vakita, and Topeka. And I think Eleanor, are you presenting on this one? Where's Eleanor? Am I not? Where is she?
Sorry, I'm right
Oh,
here.
there she is. I'm like, where's my braiding bench?
And the reason is because this committee does not have a lead drafter. So typically the lead drafter, as we go through the agenda, you'll recognize as the one who presents on this. So what I think we are hoping to accomplish here is one, to assign a lead drafter, recognizing that Brandon isn't here and neither is Nikita. So that could be tabled as necessary. And then in the past, we've discussed hopefully having individuals who are not committee members participate in a working group, individuals who may have more experience in particularly criminal law to join and provide input as to these issues. And so I know I received one person as a recommended additional member of the working group, but not just for the existing working group with COPRAC, but for anyone who's not on this working group. If you know somebody who has criminal law experience and who may want to join on an informal basis to kind of provide some guidance as to client file retention, it would be very helpful, I think, for the committee. The committee doesn't currently have anyone who has criminal law experience. When we started this opinion, we did have a DA on the committee.
I think, Emil, not to drag you in, but I think having somebody with an IP background might be useful as well, because it's different, and I think it presents unique issues with respect to retention. I think if we could get a couple different perspectives in a meeting, we can probably move this along pretty quickly, because there's a lot of work that's been done. I think we just need to kind of pin down the edges that we don't understand.
I am happy to participate. So.
Just to know,
Can I ask? Yeah,
for the new members, when
sorry,
someone says you're not going to get dragged in, then you're about to get dragged in.
Yeah, absolutely. Thank you.
Eleanor, can you, what do you mean by the IP aspect of the opinion?
Yeah, I'm thinking somebody with an IP background commenting on retention periods could be useful to us, because I think unlike like many files, the criminal are unusual because they can be relevant for the period of incarceration, potentially for the life of the individual client. IP, I think, can be relevant a lot longer. They have longer tails, those types of matters, than the average with the statute of limitations that.
Yeah, and actually, you know, not to get too far afield in this, but there's actually a school of thought in IP. It's called the clean file method, where some boutiques actually destroy their files after the patent issues. I don't subscribe to that, but you know, they do that.
That's a really good, Emil, we talked about that. Remember, I had that question for you, you know, about a month or so ago, and I forgot about that. But yeah, that's a really important point, is that, you know, I had a question from a client, said, my client wants me to destroy the file because of this very thing. And I just, yeah, and it was, I think I posted as an April, on the April listserv kind of question. But anyway, so yeah, that's a good point. I'm glad you brought that up, Eleanor.
Just curious, is the idea, Emil, that there would be something in the file that would be prejudicial to the patent or something? What would be the idea?
Yeah, so a lot of times the patent prosecutor becomes a mandatory witness that's used to basically describe, you know, what happened. They go back and look at the file to say, this is why something was submitted to the USPTO, or hey, this was not submitted to the USPTO. And because it's considered ex parte and there's a special duty of disclosure provision, a failure to do something could be deemed to be material to patentability. And by seeing in the file, they kind of infer some sort of intent. which creates an allegation of inequitable conduct.
And I forget, the opinion doesn't touch on this at all, right? This particular issue? Eleanor? It doesn't.
No,
I mean,
I hadn't even thought about it really until seeing Emil, and I was like, that's another issue we need to give some thought to.
Yeah. I mean, it might just be a good footnote. Yeah, like a footnote type of thing. Yeah.
Yeah.
Yeah, that's what I was thinking. Like it's, it doesn't touch on everybody's practice. It's probably very limited, but it is a good, it's the perfect opinion for a footnote like that.
Right.
Even just the concept that a client requested you specifically to destroy a file that the opinion otherwise says you should keep.
Right.
It's all of that.
Okay, good. So are we moving on with what do we decide what's happening for that opinion?
If we need a lead, I'll be the lead for that. Since we currently do not have a lead.
I think the next step was to get the larger working group together. If we only have one criminal voice, maybe we just move forward with the one. I mean, we can, if you want, I'm happy to reach out to others. I only reached out to one, or I reached out to two, and one was like, I may not have time, but I might be able to drag them in if we think we need more than one.
I have one person in mind too, who's in the process of retiring, and I'm sure they probably have some very strong opinions on what they need to do with their whatever documents they have.
Oh, that'd be great. And that'd be another unique
I think that would be a really helpful insight are those individuals, because makes their retirement process a bit difficult.
Yeah.
Well, then we should add it to succession planning. Just kidding.
Thought we were done with that one.
Yeah, we're done. Sorry. I'm not going backwards. Okay, so we've got Mary Grace is gonna be the lead. And then do we have the working group? Is Mary Grace, Brandon, Eleanor, Akita and Topeka, and then we're gonna try to get a criminal lawyer as well, and then Emil. That's a huge working group. Or is it too big?
So we are okay, but I'll note that Novella has her hand up just in case she was.
Oh, sorry, Novella, go ahead.
No worries. I also had a attorney who I could suggest for the criminal lawyer. She works at the Alameda Public Defender's Office and used to work at the San Francisco one.
Okay.
If you wanted to send her contact information or share mine with her, that'd be great. And I can.
Okay.
Okay, great. Okay, moving on to 4.2, which is opinion 20 -0001, lawyer as expert witness. The working group is Dan, Carrie, and Brandon. And I think Dan, you're going to give an update. Maybe, yeah.
Yes, we met and discussed a few of the revisions that previously had been circulated. This is a brand new scenario 3. And in our meeting, we decided we want to go back and take another look at scenario 1 and 2, just to focus on the non-California case law and see if we can adjust that and then update it, because this one's been around for a while. So I wanted to double check to make sure there weren't any other new developments that shouldn't be reflected here. So I expect that we're going to have a fully revised draft and a red line that we can share at our next meeting. And then it should be in decent shape to tighten it up and then possibly send it for comment.
When is our next meeting? In January, right? We have.
Right.
Okay. Okay, moving on, conversion clauses. Opinion 20-000005. Deepika, you are presenting. What's going on?
So the working group has met a couple times since our last committee meeting, largely to discuss whether there's a path forward for this opinion, kind of given the historical diversity of perspectives on these issues. And the approach that we have presented, I think, is a three-pronged approach. So One is to try to streamline the opinion, which prior versions of the opinions have tried to address the broader question of whether conversion clause are always permitted or never, or some in between, which historically has been the subject of robust debate within the working group and the committee. So rather than trying to address that question, really streamlining the discussion down to certain situations where there might be more consensus, where conversion clauses would be prohibited by the rules. So where they have the effect of infringing on a client's rights to control the objectives of the matter, to discharge counsel, or where they might result in an unconscionable fee. So we've been doing some work to just slim the opinion down to really focus in on some of those areas where we think there's been historically more consensus around those scenarios. And then the second piece we discussed was potentially adding some acknowledgement that there might be some ambiguity here, that there is kind of potential differences of opinion and room for that, and just discussing, whether there's certain assumptions that might be baked into situations where conversion clauses are not permitted by the rules, and whether those assumptions necessarily are present in all conversion clauses. For example, whether contingency agreements always include a risk premium is just one example of an assumption. And then the third approach we suggested is, rather than presenting this in the form of an ethics opinion, potentially pivoting and presenting it as an ethics alert, which we think might be a better format potentially to just reflect the diversity of opinion again that we've heard through the committee, and recognize that there's certain situations that the advice focuses on where conversion clauses might not be permitted by the rules. But that we're really focusing in on a narrow set of issues, and there's many more other potential issues out there not covered by this guidance. So looking forward to hearing thoughts on taking that approach.
The only thing
Eleanor, I don't know if you have anything to add to that.
Yeah, I would add one thing. I think one of the things that we discussed at Beacon, I think we made great progress just in terms of our thinking about how to approach the opinion, was talking about, I think it's 1.8.1, business transactions with clients and the fair and reasonable standard there. And I think that standard reflects a lot of the concerns certain committee members have about these clauses, and how a contingency can kind of be like taking a business interest in a matter. And if you're going to change that, that contingency in the entire agreement must be fair and reasonable at the time you do it. So, and I think that concept lets us address a lot of the concerns certain committee members had that I don't think were covered by the other rules. At least in my opinion, I was struggling to acknowledge those, or with how we could address those concerns under the rules we were looking at previously. But I think if we import those principles, it gives us a way to address them. And it also allows the flexibility to say that they are sometimes permissible. If, in cases where maybe there's no risk premium or the risk is actually being transferred to a lawyer, there are no policy concerns here. In cases where the risk transferring is fair and reasonable and you have a sophisticated client that's bargaining for it at the outset, it could be permissible. So those are the conversations we were having. And I think using 1.8.1, I'm pretty sure that's the rule. I haven't looked at it, but helped us kind of flesh this out, and talking a lot about the potential hypos involving sophisticated clients and transactions. Also, I think got us to a place where you could see the potential for permissible conversion clauses. So I think we agreed we don't want to say they're per se prohibited.
Did we talk about 1.8.1 in connection with this opinion before? I don't think so.
No, I think that came up in the meeting Deepika and I had earlier this week for the first time that I remember. And it was very helpful because it just provided a way of addressing a lot of concerns that we hadn't discussed before.
I think that's right. I joined this particular working group just a few months ago, so haven't been part of as many of the conversations, but that particular rule isn't addressed by the prior draft opinions that were circulated on the topic.
Because it's an interesting twist, because it's, there was an alert way back when to say that 1.8.1 applies to modifications of fee agreements, like midstream modifications. And that's kind of what this is. It's like a springing modification, you know, but it's in the original agreement, but it's, you know, a modification of the fee agreement contingent on something happening. And so, yeah, I mean, that makes sense to me to analyze it in that way. And I think it probably does sound like it provides more flexibility. And thank you, Topeka, for laying that out so clearly, the 3 points. I don't know how I feel about it being an alert. I think it's a much more meaty opinion or meaty subject matter that maybe shouldn't be an alert, but I don't know, what does everybody else think about pivoting to an alert? Anybody? Nobody?
Raquel's got her.
Oh, so go ahead, Raquel, sorry.
Can you just restate what the 3 options are and why, particularly the alert? I have a assumption, but if you just maybe say specifically why you're thinking of that.
Absolutely. So I think the 3 options we discussed, and we can, you know, tackle one or more of these, was to streamline the opinion significantly so that it really focuses in on certain scenarios where there might be greater potential to reach consensus, where conversion clauses would not be appropriate. So that's where they're operating to penalize or otherwise inhibit a client in exercising their right to control the objectives of the matter, or where they're penalizing a client for discharging counsel or limiting that right, or where they would just result in an unconscionable fee. So really, rather than trying to address the bigger question of are conversion clauses ever permitted and in what circumstances, really streamlining it down to those particular situations. And then the second piece was to address the point that Eleanor just made about the application of Rule 1.8.1 to this, and are there certain assumptions kind of baked into the prohibition on conversion clauses that might not always apply? And I think that's a piece that we're still thinking through, but we had a really helpful discussion about it earlier this week. And then the third piece was that idea of presenting it as an ethics alert. And I think the thinking there, Eleanor, please let me know if this captures our discussion, was to just reflect the fact that with these revisions, the opinion would be significantly streamlined down. It wouldn't kind of be addressing the larger question. It would really be narrowly focused on certain circumstances where committee members have identified that they have seen impermissible conversion or potentially impermissible conversion clauses in the course of what they have seen in their practice, and addressing those scenarios. So it would be rather, I think some of these draft opinions have run quite a few pages, and what we're proposing to present, you know, hopefully by the time of our next meeting, would be much more streamlined and shorter than that. So perhaps makes more sense to present as an alert rather than as opinion.
Okay,
Yeah,
maybe
it's a rough draft that was created that was really just focused on here are the circumstances where we can agree they would be prohibited. And to kind of address the concerns I think a lot of committee members have raised about the abuse of them in cases involving perhaps less sophisticated, you know, purchasers of legal services and people for whom the clause would potentially serve as a penalty for changing counsel or discharging counsel, even with cause and, you know, with good reason. I think there is an opportunity to still draft something that's broader than that based on the conversation we had earlier this week. But I'm, you know, I guess it would be interesting to hear the committee's views on, you know, if we end up only reaching consensus on the narrower, more streamlined version, how do people feel about that being alert as opposed to a full opinion?
I think we need to first kind of maybe, you know, figure out how we define what an alert is going to be and what an opinion is going to be generally, you know, because I tend to agree with you, because an alert is more about, and I was struggling with this as well when I was doing the in-house opinion, and I was kind of thinking like, this could have been an email, you know, or this could have been an alert, because now we're getting to a point where we can't really opine one way or the other, but we have this cautionary message. that, you know, that we want to get out there, and that is more appropriate for an alert. So that's my sense, and I'm kind of like agreeing with you that maybe this should be an alert depending on how, you know, the streamlined draft comes out. But my view of an alert would be, you know, there's no definitive answer to the issue, but there is, you know, perhaps guidance or, like I said, a cautionary message to put out there. So,
And I think that's why Topeka recommended it. She's like, we can at least all agree that these abuses are not permissible and these circumstances would be abusive, and we can get that message and warning out there to address what I think is a critical concern for a lot of committee members. And we might be able to do more. You know, we've made progress on the possibility of doing more, I think, and maybe getting a consensus built where we all feel comfortable. But the alert also felt appropriate if we are really split as a committee right down the middle, which we seem to be at these votes. You know, like if we can't agree, or more of us can't agree, then maybe we shouldn't be out there yet with an opinion.
well, okay, yeah, so let's make that decision at the next meeting when we have this draft. But you know, consistent with that, maybe the bigger project here is to come up with some criteria for alerts versus opinions, and we haven't done that yet, right, Erica? I mean, and that's something that we can do, like Dan and I can do, you know, as officer positions.
I mean, I'm personally in
discuss-
favor of streamlined, more narrow opinions that are much more focused. So I wouldn't have a problem issuing something like that as an opinion. And even opinions that don't give you black and white answers, which many of our issues just don't lend themselves to. But alerts.
Yeah, but can we do that? I mean, is that a kind of a policy position we want to take, which is, are we going to issue opinions that aren't opinions, but just.
There are opinions of the risks, and then we don't know the facts. We're outlining the problem. That's useful for practitioners. Well, especially on some of these issues, those two issues that we are talking about, in-house lawyers and conversion clauses, are groups of people who currently have no generally consideration of either of those risks. So that's news.
So then it should be, right. And then the other consideration is alerts can be issued without going through the full process. And so it's a timing issue too, like, you know, with the judge threats, we want to get that out there sooner rather than later.
Yeah.
Okay. So any thoughts on kind of my scattered thoughts on that? I mean, I do think we should come up with some better criteria, so we're not always like, oh, should this be an alert or there should be an opinion? You know, I think we should have some, you know, a better criteria that we can distinguish between the two. Okay, we got Erica and then Mary Grace.
First, I'll just briefly say, so we do have several hot liner articles. That's typically how they were done. And these were done by both staff of the state bar as well as by COPRAC. It kind of depended. Some of them are drafted and it says the author's name, which is a former COPRAC member who was active in COPRAC at the time. Sometimes they're authored by COPRAC itself, and sometimes they were authored by state bar staff. But what we can do behind the scenes in the meantime is we can go through those and kind of see if there's any themes there as it relates to if they are where there's no settled area, or if it's such a settled area where it's almost obvious, but it needs to be applied to an existing rule or statute. And then we can also talk about, you know, if there are areas where there, like I said, where there's nothing settled in this, so it's more of an issue spotting and issue raising for kind of attorneys to be aware of these considerations before they make their own independent determination. I will just say, you know, the COPRAC has traditionally mostly focused its work on opinions because they have the benefit of kind of more participation because they're a little bit crowdsourced with public. But that being said, I do think there, you know, as we'll get to the planning session when we go through the kind of inventory of existing ethics opinions. COPRAC is at a time where there's just most of the big issues are settled in one way or another. And so you're looking at these very kind of more discrete issues that may not necessarily have as broad of applicability. and those types of things. I give off this more like quick advice in a way, for those individuals, who need it and need it kind of more quickly than deliberating over things for a significant period of time where it may not have a universal applicability like most co-prac opinions do, or at least a larger applicability to more attorneys.
Okay. So, I mean, so part of your message there is that we want to tend towards, we want to have more opinions where if we're going to make a decision between an alert and opinion, we want to weigh more towards an opinion because that's our role as the committee. Okay.
I think so, and they have higher value because they are approved, they go through public comment, they are approved by the Board of Trustees. And so they do oftentimes cited in case law in one way or another, sometimes saying that they are just advisory and I don't have to follow them. But so I think there's value in that to some extent, whereas, the articles, they're articles and article you may see in.
I know. I mean, and that, yeah, I mean, we know that, but it's so funny because now we're like, well, maybe this should be an alert, like we're kind of like, now we're knee jerking that, thought. And so I think we need to pull back a little bit, but okay. Mary Grace.
I think Erica might have answered my question because basically my question is like historically the, co-prac issuing alerts and then consequences and confusion from attorneys when an alert is received. That would be my big concern because I know that we've spent so much time historically, talking about this particular issue and then issuing an alert, especially if it seems like such a hot button topic for those who it impacts. Yeah, I'm just a bit concerned about the consequences of that and like the historical role of issuing an alert versus a fleshed out opinion.
Yeah.
And so, but I do think Erica more or less answered my question.
Okay. Yeah, I mean, I'm glad we're kind of fleshing out the concerns and trying to figure out, how we're going to make these decisions. Okay, and then I thought I saw Raquel.
You did, thank you.
Yes.
I think a couple of things. One, I think it would be helpful to hear from everyone, sort of just, we're starting to do it a bit, but we almost went to the next subject, which is just what do people think based on what they've heard? Because I think that would be helpful. And it would definitely be helpful to me to know. And I'm going to share mine, but I also would like other people to share theirs. And so I do appreciate what I've heard. I'm not in favor in some way of looking for a solution based on what people can agree on. I think that's not helpful. What that says is talk more, think harder, be deeper. I think what was uncovered with what turned a light on, it seems like for you, Eleanor, was the 1.8. And I don't know if it has a point what, but and so I think the idea of saying, well, this was really important, but since we can't agree, or we think we can't agree based on what's been done in some way with a different working group, because I think the people who had the strongest opinions are no longer part of the committee. And that doesn't mean don't take what they had to say in consideration, but I think overweighting it and saying now this committee couldn't agree on something probably is a bit of an overreach because, we don't know that. But I think the biggest thing is just saying, I wouldn't focus on the decision we make based on what we think we can agree on. If it's still important, I think, we don't have the only clock we have is the one we're setting for ourselves to say either we're tired of working on it or, we've worked on it for so long. So that would be my encouragement, is let's not set ourselves up for compromise if we think it's still important. Because if we're struggling with it, then we know and that the people this is supposed to be giving guidance to haven't even thought about it nearly as much as we have, which means it creates greater risk. Again, for if one of the part of the mission is to protect the public, then this is one where risk is increasing because those of us who are spending time on it sort of haven't broken the code, and so we know people are just operating without a lot of thought. So that would be my encouragement, but I really do want to hear what others have to say in different perspectives. I think would be helpful at this junction. Thanks.
Right, did anybody have any comment? Well, I mean, it's maybe a little bit premature right now to get more substantive comments about this opinion without seeing the streamlined draft. So I think that once at the next meeting, when we have that, then we can have a full robust discussion about, application of 1.8.1. Are we going to keep it, as limited as possible? And then trying to reach that consensus that you're talking about, Raquel, as far as, not throwing up our hands and saying we can't reach a decision. So, let's do an alert or whatever, whatever it is. But I'm encouraged by the fact that I want to see what the 1.8.1 analysis looks like. I think that might be the key to it. Okay, anybody else have any insight or comment or further thought?
Oh, let me just say mine is not on the content. Mine is on the committee's 3 options. Right. So if we don't hear until next time that the committee wasn't in favor of streamlining, we've gone in a direction that was not helpful for the committee. So
I see what
what
you're
I'm
saying.
saying
So
is before we get started, what do we think about what we've heard about the framework in which we're considering versus not hearing, taking an action, and then realizing
everything could be on the table. Yeah, I mean, so
yeah, so I'm
we'll
not
have-
into the detail. Mine is not into the content. It really is what you all served up. Here's how we're thinking about it. What do we think? We have Carrie. She's new. What does she think just generally based on what she's heard, and she's a fresh set of ears, right? Because she doesn't have the history or email that some of us have who've been living with it for multiple years now, or Novella. I see Novella has her hand. So that's the point. It's just more voices before we go and set off on a track. And I don't know what the people are going to say because they haven't spoken, right? So they may say, I don't have anything, but the point is to ask to get us to be sharing where we are now. So the committee can make a more informed direction on which way to move, knowing that the people we're looking for consensus to have at least said something before we take a vote.
Okay, well, I'm gonna make one comment, and then I'm gonna go to Eleanor and then Novella. What I think, and I agree with you, Raquel, we're not, I think that the 3 options or ideas that Deepika was talking about is in addition to looking at the original opinion and, fleshing it all out. So it's all on the table, and we can talk about that, the content and the approach at the next meeting. Okay, so Eleanor, go ahead.
Yeah, I wanted to let Deepika know she's on mute because I've seen her lips move, and I want her to know that we're not hearing her because she might have something important to say here. And I'll say what I think, and then Deepika, please chime in if you had something to add. She's been leading this. I think it's premature. I mean, as working on the opinion with Deepika, I think we made a lot of progress on the opinion, streamlining it. We already have the streamlined opinion or a draft of it. So that maybe wasn't clear for Raquel. So that work's been largely done. What we're doing now is discussing ways we can expand that more streamlined draft to incorporate these other ideas we've had and the discussion we had. And I think we're going to work on that. So we'll have something a little more robust to share with the committee to have this discussion. Because I don't think we were looking for a decision today on whether or not to go with the opinion versus an alert, but that it might be a good thing to consider once we've finished this draft.
I think that's exactly right. I'll be very quick because Novella's had her hand up. But I think what we were looking for is exactly this discussion of whether one of these paths forward would be sensible, if there's other alternatives to consider. And I think it's really helpful that there are multiple fully fledged drafts of this opinion that take very different approaches that were drafted by other prior members of this working group, that we have as a resource to draw on, depending on kind of in this meeting or in future meetings, what people think should be included.
All right, Novella.
Yeah, I would be interested in seeing whatever draft of whether it's the streamlined or more full-fledged that the committee wants to put forward. I think when the alert idea was raised, I was also like Cassidy interested in knowing like what would be the distinction between those different approaches. But then when I thought about the opinion we discussed last time where we weren't really agreeing, like reaching consensus on things, I thought that the opinion could be helpful even if we didn't, because I thought the like analysis and issue spotting was pretty rigorous. So I guess even where there isn't like consensus, sometimes there is like value in an opinion that doesn't say like, and this is the right answer.
Like somewhere like just guidance, like what Dan was saying. Okay, anything else? Thank you, Novella. And there's only three people on the working group. Do we think we need more people, or are you guys good on the working group?
Honestly, from my perspective, and I'll defer to Topeka, she's leading it. So, or, whatever she says can go, but I think we're in a good position to put something forward. We've had productive discussions. So given the history of this opinion, I would say let us do that. And then if we need to expand it, we can expand it.
Sure. Yeah, no, too many cooks is not necessarily a good thing.
I would say in terms of handling the workload, I think we've got it covered, but certainly if others are interested and would like to join, we welcome anyone who would like to join. In terms of kind of handling the drafting of the next draft for y'all's consideration, we feel good about being able to handle it.
Okay. All right, we'll leave it at that then. Okay, let's move on unless there's any other comments or questions on this one. Nope. Okay. So the next one is, or do you guys want to take a quick break? Or are we good? Keep going? Keep going. Okay. So the next one is the ethics of in-house counsel, which is me and Raquel and Dan. So you recall that we broke up the opinion, the in-house counsel opinions. One is just for the 1.8.1 analysis, which is the compensation issue, whether or not an in-house lawyer can be given stock or stock options without having to comply with 1.8.1, which is the business transaction with a client. And then the other piece, Emil, that's another opinion now that we've broken out that Emil is taking the lead on that we'll talk about briefly later on, I think, yeah. So one of the issues that was brought up in the public comments was that we didn't have enough authority to say that 1.8.1 does not apply when you're talking about a traditional in-house lawyer who's hired as any other employee who gets the typical stock option package like all other employees. Lawyers are whether you're an in-house lawyer or firm lawyer, the rules apply to all lawyers equally. So we kind of took another approach and basically said, and this is kind of along the lines of, we can't really issue an opinion one way or the other. Should this be an alert kind of question? But basically saying, look, the rules apply to you in-house lawyers. 1.8.1 applies to you. So you need to understand the risk of non-compliance, and so I changed the opinion to reflect that that 1.8.1 does apply. And so if you are being hired by, as in-house counsel in a legal department, by a company that gives you an employment agreement or, stock option package, you need to consider whether, 1.8.1 applies. So I'm gonna leave it at that and see if anybody has any comments on the red line that's here. Before I ask for comments, I don't want this to go out for public comment quite yet. Even if we vote, I don't want to vote on it, because I still want to tweak the language. I was reading it this morning and it needs a little bit more work, but I'll leave it at that and see if anybody has any comments.
Just from, oh, sorry.
Yeah, go ahead. Thanks, Nina.
Raise my hand.
Yeah.
There's like a little electronic hand raise. I'll do that next time.
That's okay.
Just what kind of stuck out to me was the reference that, they do this without having complied with the rule. That, I don't know, it was to me as a practitioner, it seemed pretty jarring to sort of say like there's an actual violation of the professional rule. So I just wonder if that's the right formulation, or if there's a different way to to position it, so we're not sort of opining that, not that we're encouraging non-compliance, but we're just kind of like advising of the risk without directly saying like, yeah, you might not comply. Like that's kind of what I was looking at there.
Right. So, and that's the struggle here is that, and that's why I said, there's this practical reality that I don't know for how long, for as long as probably, the rule 1.8.1 and the previous rule that we had, in-house lawyers in this type of situation haven't complied with it. I mean, so, we don't want to, I don't want to say that, it's a violation that, well, I don't know. I mean, I think that it's, we're trying to address the fact that we're telling all these lawyers now, look, this rule applies to you. You should know that. I mean, that's kind of the message here. But now they're going to go back and look and see if there's, this client consent provision. And the other thing I was thinking about is that as a practical matter, possibly, these stock option packages, probably do comply with 1.8.1 because they are fair and reasonable. That the employer is signing it as consent, I suppose.
That's
And
yeah. I was
yeah.
I mean, and they're not always, I guess advised on, because I've dealt with this. I've dealt with a lot of emerging companies, and I see, folks go in-house all the time, and they get as part of their compensation package, stock options or any type of sort of equity, that it kind of vests with everybody else. And this is part of that process. There's obviously a negotiation that happens, like the new counsel comes in and says, I want this, and then usually the company is represented by somebody who's not that counsel in negotiating that. So it's a practical matter, but I'm sure there are situations where there are no lawyers involved, and we can encourage. I think it's a pretty. I think not only the ask is too big here, which is essentially like advise the client. Like if you're going to get ownership interest, all you have to do is basically explain what's happening and get it in writing, and tell the client, your client, that they have the right to seek counsel and get reasonable consent. And if you don't do that, I think as Emil put into the comments, which I thought was very good, here are the risks of not doing that, as opposed to saying, uh, you know, we realize that perhaps that most people don't comply with this, or a lot of folks don't comply with it.
Right, so, and that's why I think that this could be an alert, because it's, you know, it's more of a practical approach to this issue, because it could be as simple as, you know, your comp package has all the language in there that probably does comply with it. You should take another look at it, and if you know, you may need further documentation just to make sure you're complying with Rule 1.8.1. And this is for those lawyers who are hired in big legal departments, and, you know, small legal departments, but, you know, established companies. And then, you know, the other piece of the alert would be to, you know, say that this doesn't apply to lawyers who are also founders, and they're, you know, they're part of, you know, like a startup with a group of people, and they're also serving as in-house counsel, and they're taking equity, you know, so there needs to be a more robust compliance with 1.8. Well, not, I mean, the compliance is all the same, but, you know, you have to be more careful about compliance with 1.8.1. So I guess my question then is, do you think this is a more appropriate opinion or guidance for an alert than an opinion?
Is that a question
Anybody?
or to the judge?
That's a question for the committee, for Nima, for anybody.
Which leads me to I guess my question / comment, is the goal to be, hey, in-house, because I know, you know, having represented in-house lawyers when I was you know, at a different firm, they don't always, they know, but they don't know that their client is who they work for. Like they you know what and so there's like,
yeah,
you understand what I'm talking about, because I'm sure you've had those conversations too, Cassidy. And so is this more of a like cautionary tale type, hey, the rules in of themselves apply to you and your representation of your client, who is also your employer? Or is the goal to flesh out how you are going to comply with Rule 1.8.1?
I think it's both, because the fleshing out how to comply is basically the message of, it's not that hard, you know, like you just need the documentation, because the situation is it's the employer who's giving you the terms, you know, and that you probably, I mean, well, Nima, maybe you can tell me that this is, and I'm sure it changed, but, you know, whatever compensation packages, are they heavily negotiated, you know, or are they pretty standard? I mean, it probably changes from company to company.
Yeah. I was gonna say, I mean, if you're dealing with a very, like, I've seen
High level, yeah,
Yes.
C-suite.
yes, you know, situations where it's a small kind of like, you know, 7 or 8 people that are part of the startup. So that a lawyer is a lawyer, but he also, or she also, is doing, you know, 19 other different things that have nothing to do with
Right.
legal work. And so so then that situation is very informal. It's like, you know, here's the package we gave to all the other executives, and take it or leave it, or mark it up, or do whatever. And then you have other contexts, obviously, when it's like somebody's going in-house at a place like, you know, Netflix or Snap, where they have a very kind of formal and diligence process that requires, you know, a lot of back and forth and communication with their in-house and outside lawyers. And so it really differs. So I mean, I think the takeaways, I agree, this should be an alert, because I feel like it's a very hard thing to kind of pinpoint exactly the context in which it arises. It's more like, here's some
Yeah.
general guidance that we think you should be aware of.
Yeah, I mean, basically it's just, hey, guys, remember 1.8.1 applies to you. So just double check that what your you know, what your comp package looks like complies with it. Emil, you have your hand up.
Yeah, so I think I agree with what Nima said, what Mary Grace said. I think those are all crucial points, but I guess it goes back to this particular opinion and the prior opinion. What is an alert versus what is an opinion? Okay. And I think it's hard for us to decide what that is unless we maybe spend the time focusing on that point. Because first of all, when I hear of an alert, I think it's something new and something that has to be addressed because it's maybe a new rule, like or a new structure like CTAP or a new CLE requirement that we have to go through. So that's one issue. The second issue is I respect, I think it was Dan that was saying that, we having an opinion, whether or not it gives an actual decisive answer is still helpful guidance. I agree with that, but I also disagree because don't we all hate when there's like a 10-page opinion that doesn't really say anything? That's what a lot of lawyers we end up writing. So I mean, it's helpful if it gives some thoughtful analysis of an unsettled area and saying it's unsettled or saying that there's many things to think of. And here's basically a link to a bunch of resources that you should read for yourself. I'm okay with that. But I like the idea that a COPRAC opinion is easy to find and easy to cite, whether you're a lawyer, whether you're an ethics lawyer for lawyers, whether you're an insurance company, whether you're a plaintiff's attorney, and of course, whether you're in the judiciary trying to make a decision on something, or maybe you're at the state bar. So maybe we think about whether we have to have an in-depth opinion that's 5 to 10 pages, or we do a quick kind of summary opinion, or we do this alert and maybe we try to capture it in a certain way. So that's just my monkey in the wrench.
So I have one other question about alerts that I think maybe Erica, you can answer. Because I know I've seen alerts throughout my career and yeah, I read them. Sometimes they apply to me, sometimes they don't. But historically, for this group, when they've issued alerts, what is the broader consequence when the public, when it hits the public, and what does that do? Because I know that, for example, with opinions, it is heavily relied upon. It might be quoted in case law. There's it goes down the line. But with alerts, what historically has happened once the alert is out there, then what? I don't know if my question is clear, but that's one of my concerns about issuing an alert versus issuing an opinion.
Sure. So I will do my best to answer that. Alerts used to be issued for essentially MCLE self-study was one way they used to come through. So it was kind of an MCLE type article. There would be questions tied to it. And this was when the bar was unified. So pre-2018. And people would pay $20 and get MCLE self-study credit and hopefully learn something. Another way in which the alerts were issued is like if there was new internet scams, if there was phishing, when loan mod happened in 2008-ish, there was an ethics alert related to that. When there's something I can't even remember who just made the point, but when there was something new, that's oftentimes when there was an alert issued. In practicality, what alerts would likely look like at this point is the state bar issues all licensee emails on a periodic basis. Those emails typically are things you need to know about compliance. So, your MCLE compliance period is coming up, your licensee fees are due on April or March 30th this year, or 2025 and so far. So it'd be something that's included in that communication. Anecdotally, those aren't that well read. From what we've been told, is that people get them and kind of ignore them, which is why people sometimes end up on administrative suspensions for CTAP, for example. And so I think that's the mechanism for delivery, but that mechanism for delivery is frankly no different than how COPRAC opinions are delivered. I mean, we would send these things out to a listserv, which is people who have signed up to get communications related to COPRAC. And then we would send it out as well through the all licensee communication. So it's in that way, it's similar. They're both on our website. They're both going to be sent out via email and perhaps, posted on social media of the State Bar. But otherwise, it's really no different. I think what really is different is the formality of them and the weight that they may carry.
Novella, you have your hand up.
Yeah, I think when you were explaining, Cassidy, why the opinion was requested, it made me go back and look at the sentence where it's saying that the rule applies equally in the in-house context. And so I wonder if that sentence is helpful without like citing anything else or unpacking given the prompt that led to this. So I was looking at the just the idea of like, okay, well, if the rule is being construed by its language, just like what does this actually say? Are there ever any contexts where a court has said, well, even though this is acquiring an interest, it's not actually an adverse interest for the rule's purposes, and so the rule wouldn't apply. So I'm wondering if there's cases in that context where we can say like, okay, we can dig in more to whether or not the rationale for that not being acquiring an adverse interest extends to this context as well, just so people don't feel like we said the rule applies for in the in-house context without actually unpacking why it does.
So just if you look, I see what you're saying. So if you just look at the language of the rule itself, is it a pecuniary or ownership interest in the client? I mean, there's, taking stock in a client as part of compensation is, I think, falls squarely under 1.8.1. I mean, is there any debate over that? I mean, I think that's, so it does apply. I mean, that was my.
Yeah, so I was looking at, I guess it's this Plummer v. Day decision and then Lance v. Goldstone, where the court was saying even though technically the rule was triggered by like the plain language, it still wouldn't apply in a certain context. So I'm wondering if there's rationale for that. We could say like yes or no. Like it seems these two cases made me think, oh, maybe even when situations fall squarely within the plain language, it seems like there's still like a gray area where courts say, well, sometimes still the rule doesn't even apply.
And where are those cases? Are those the ones that Erica or the research? Was it the research? Where did you get those cases?
I just got them from Westlaw, but I can put.
Oh, okay. So you did your own research. Are they California cases?
Yeah.
Like, for example, like a charging lien in a contingency case. Is that kind of like what you're thinking?
Yeah.
Case law has excluded that from a 1.8.1 requirement. So are there other examples?
Yes.
Could we extend that to this context without there being case law on it?
Okay.
Right.
So, sorry, Novella, you sent that only to me, so I just sent it to everyone else.
Oh, sorry. I don't know why it's set up that way. Let me fix my chat box.
Okay, well, so thank you, Novella. I'll take a look at those because I'm gonna revisit this, and I'm actually going to see if I can recruit Nima to join the working group on this. So that, yay, good. So I'll and anybody else, because it's just me and Dan and Raquel right now, right? So right, no, what, Erica?
Working because if you recall, this was the one where we had to collectively keep it below, keep it at 6 because you were cross communicating across the two opinions.
Oh,
And,
but can we have Nima join?
only if you're willing to remove yourself from 24-0001, I think is the issue. Because this is, the opinion was split into, the current opinion 21-0003, and then it was split to, ethics of in-house reform for IP.
Yeah, okay. Seems like a very arbitrary and strict rule. But I'm willing to take myself off the other one. That's fine. I'm sure Emil, who else is on that one? Emil is the lead and
Emil,
Raquel,
Vikita.
Nikita. Okay.
or I'm silent, I'm mute.
Okay. Yeah, I mean, if they're okay with that, I'm okay with it too. Because I just want, yeah, I want Nima's insight on this since he has more experience with these types of comp packages and we get some new fresh blood on this opinion, so we can just get it done, or we can decide to do it as an alert, whatever, you know. Okay. So, and then I'll take a look at those decisions novella too. To see if it makes sense to say that it doesn't apply, right? I mean, kind of back to the drawing board, but I'll take a look at it. Okay,
Cassidy,
anything else?
before you move
Yeah.
on, I did want to say something.
Yep.
Which was, and I think it's the similar point that I forgot it was at the beginning. So I think it was Nima. But line 27 is the one that did strike me, and I realized in the working group it didn't. I guess I didn't focus on it, but I do think having an opinion, being an ethics committee that says even if you elect to forego. So I think we shouldn't say that, right? Because we shouldn't be encouraging people's mindset that it's a risk that you should, like, it's a risk you could take, even though that they can. So I thought that Emil put some language, and subsequently we've had different conversations, but I did want to chime in on that and say also, that's the line that I saw it most specifically, but I also thought it was weaved through the opinion. And I do think it is an opinion because I do think we are trying to make a couple of points, as you indicated, which was the idea that an in-house counsel is separate than any other employee, which I do think, I think I said it from my own experiences, that attorneys inside of firms do not at all think of themselves separately. And they don't comport themselves in that way. And certainly the higher you are in the organization as an attorney inside, you have more, you're working more around negotiation, but the lower in the level, the form of what you get is sort of by, I'm just going to say grade band, if you will. So you don't have a lot of interaction with it. But I do think if sort of rising that up to the level where people, you might know the rule, but you just don't think about it in that context. And then I think the idea of giving guidance, and Novella talked about the idea of, it has value if it has some analysis and some things to think about, that the opinions can still be valuable. And when I hear Erica say, well, here's how we use alerts, I'm not sure there's anything that we're doing should, I don't want to say lower itself, but should move towards an alert level just by definition. Because I think we are saying things that everyone should be looking for and should be opening their email. And it is, as Erica said, people don't read it, and how you know is because you can look at the statistics and see the email's not opened. So to me, we would have to, based on that sort of frame that Erica had, which would take a lot of change to get people's mindset to be in a different direction about alerts, which I don't think this committee can probably lift up in the state, to the members. So, but I think, but the main one on here is the idea that Yeah, I think as ethics committee, I'm not sure how we sort of acknowledge that people should forego rules. And
Well,
certainly they will, right? But I don't think we should encourage it.
No, I mean, yeah, so just to kind of wrap this up, I think the first step here is just to rework this opinion as an opinion, and then we look at it and then decide, okay, is this more an alert? Okay, so like, let's not put the cart before the horse. I'm gonna rework this opinion. I appreciate Raquel and everybody else's comments that, we should be very cautious about saying, yeah, you can take the risk of non-compliance, that's not, and so this needs to be reworked because that's not really what the message here should be. It's, we're trying to deal with the tension of, we know that, this rule is not at the forefront of the discussion between attorney and client or employee and employer when you're dealing with these types of comp packages. And so we want to, the alternative is to say everybody else is, you've been in non-compliance for decades and now you got to comply or else you're going to be in violation of this rule and you're all going to be disciplined. I mean, that's not what we want to say either, So we're trying to, the language is very important here, and I admit I've been sloppy on it. So I think it just needs to be reworked so that we're very precise about what we're trying to say and message. So that's my plan with the working group's help. Hopefully we can get a better version by the next meeting. Any other comments? No? Okay, let's move on. Thank you, guys. Sorry. Okay, attorney as expert witness, it's 4.5. It's presented by me. So I think we just need to get a working group together on this one because it's just me and Brandon. And I haven't really looked at it. I know I did an outline a while ago with Joel. But maybe, Erica, can we just, I need to go back and look at the outline and just see what it is we're trying to do here before we get a working group together. I'm not prepared to, so can we do this one next time and get the working group together next time? There's not gonna be anything for the working group to do between now and the next meeting.
Yeah, just for those who are curious what it's actually about, it's the question of whether an attorney is required, if they are serving as an expert witness, that they are in acting in an attorney capacity and therefore required to put funds into a client trust account.
The trust account, yeah.
Because they are acting as an expert and there's no attorney-client relationship formed if they are not required to put the funds into a trust account. This is interesting as it relates to 1.15 analysis. I think it actually becomes a little bit more interesting now that there's CTAP requirements. So for example, if the attorney only serves as an expert, would that trigger 1.15 obligations, which would in turn trigger CTAP compliance and so forth. So we'll get to CTAP compliance, I think, later this afternoon because we did get a new opinion request that's related to it as well. But I just want to give that little bit of context because it could be helpful when we talk kind of more broadly about possible.
Okay. I mean, I could just circulate my outline to the working group, but I think we can wait, I guess. Okay. Cryptocurrency. Eleanor and Bill, what's going on with 21-0007?
So no progress to report. I do want to put out a call. I think the working group was just Bill, me, and Justin. Bill, I see you're on the call today. I don't know if you were ever able to send what was the latest draft, but it would be great if you could circulate that one or send that over to me as soon as you get a chance. I expected to make progress on it this time, but did not. But I would like to put a call out for one additional member to join this working group. We do have a draft that's pretty far along, but there are some issues to work out, and it'd be good to have somebody to bounce ideas off of before we finalize it.
Just.
I had volunteered for that originally and then never. I guess we didn't have a meeting, so I did say
Yeah, we
back
did
to
not have a
staff.
meeting.
Yeah, so
Okay.
I was on that committee from probably,
Oh,
I guess, last year.
I didn't realize that. Okay, so Raquel, and I saw Nima, your hand went up.
Yeah, I was just gonna note that blockchain and cryptocurrency is a big part of my practice.
Would love to have you.
So happy to contribute. if you need
That
me.
would be fantastic. Thank you. I appreciate that. So that's terrific.
I'll set a meeting for the four of you then, apologies Raquel, and get something on the books, hopefully in advance, of the January meeting, if that, Eleanor, do you think it's in shape to do that, to meet before?
January, the only reason I'm a little reluctant to commit to that is because of the holidays and travel. I think it's not going to take a ton, but January might be, we can try, but January might be a little tight.
Before January's meeting, and not necessarily have a draft, but
Sure.
we'll send late some if possible.
Okay, and sorry about that, Raquel. I knew you had offered. I didn't know you actually wanted to be on it, so apologies.
And I'll circulate the most recent version that I had. I'm sorry, I'm lagging on this one, so I apologize.
Okay, terrific.
So Eleanor, you're the new lead. I was going to call you chair. You're the new lead of the committee.
Yes.
Okay, all right. And Bill's, you're remaining or you're handing off?
No, I'll remain.
Okay, thanks.
For sure.
Okay. Moving on to 4.7, and this is the 24-001 Ethics of In-House Counsel. And I am no longer on this working group as per 10 minutes ago. But Emil is the lead, and I think you can just give us an update of where you are on the draft.
Happy to do so. So first of all, on the committee, it's Carrie, Vikita, and myself. Cassidy, you're no longer on the committee. We're happy to have somebody else. Right now, it is on my plate. I was making edits to the draft that Cassidy, that you had last kind of worked on and sent me. And I've just been a little bit tied up. So I'm hoping that in the next probably 2 weeks, I'm going to go back to our subcommittee. But if anyone is interested in joining the committee, happy to have more eyes on it. But I'm hopeful that at our next meeting, we'll have a draft ready to show everyone.
Okay. Does anybody, so we can have a substitute in for this one. Does anybody want to volunteer to join this working group? Mary Grace, okay. Great. So it's 11:30. Can we take a 5-minute break? Just a quick bathroom break? And then we'll come back here and finish up, but probably, well, we'll see. Finish before lunchtime, but we'll see. Erica, were you gonna say something? No?
So timing wise, we have the judicial threats rules, a few quick opinions to talk through, and then symposium and just 2025 ethics opinion planning. So we probably have another, who knows, 60 to 90 minutes to go, I'd say. So we can maybe take a 5-minute break, and then you all can decide if you want to push through and finish versus taking a lunch and coming back.
Okay, sounds good. Think about that on your 5-minute break. Everyone. Oh, sorry. Okay, so now we're on the sorry, there's like work going on at my house, so if you can hear a chainsaw apparently. And maybe just me.
Can't hear it.
Okay, good. we are on item 8, the draft arbitration advisory that Erica, you're going to present.
Yes, and this will be very brief. So at our October meeting, this was something that had previously been Elizabeth Bradley was the lead drafter on, and she is no longer with the committee as a Judge Bradley, as you mentioned earlier today, Cassidy. So as we discussed the fact that there's not frankly too much to do in this opinion. It's just to make some minor changes in response to some public comments that were received on it. So Emil graciously agreed to serve as a working group of 1 once staff makes those changes, just to give it a committee member set of eyes. So that should be done. It will be done on staff side in end of this month, and hopefully we can put the 2 of us turn it around to you to be presented at the January 31st. The only challenge on that, I'll just say, is I believe, Emil, you're unable to attend that meeting, so we may want to push it, but you and I can discuss that.
Sounds good.
Okay, let's move on to the rule item 4.9, request to amend rules of professional conduct, the judge threats issue. So that's me and Vikita and Deepika. Sorry, you guys, your names are so similar. So this had a very productive group, and we've met with a growing group of judges from the CJA, including our own Elizabeth Bradley, Judge Bradley. And we met, like a couple of weeks ago or 3 weeks ago, and went over the revisions that we originally did. We originally worked on at the last meeting, and we had Erica, why am I blanking on OCTC?
George Cardona.
Yeah, George Cardona. There as well, and he was very helpful in providing revisions. We had this full discussion about, the free speech issues, and what we were trying to accomplish was to put in the comment that, not just that free speech, that the rules are subject to the right of free speech, but the limitations of the free speech restrictions. So we talked about these 3 elements or 3 buckets where free speech does not come into play when attorneys are making comments, social media, in public, or directly to the judge, like that case that you circulated, Erica. I thought that was very helpful, and we'll get to that in a second. That will subject lawyers to discipline. And I think, so what we have here, the main change is to 8.2, right? You scroll down a little bit, Angela.
Yeah, it's
8.4. No, it was 8.2, right? Why am I?
So since October, the major changes, so just a little recap. So at the October COPRAC meeting, the committee spent a lot of time talking about this and had a very good conversation. And ultimately what was decided was to make no recommended changes to Rule 3.6. The Rule 8.2 language changes are unchanged since COPRAC's meeting in October. So that was COPRAC's recommendations that you're seeing on screen to Rule 8.2. The most substantive changes as for consideration essentially are to the comments in Rule 8.4. So the comments to Rule 8.4 was developed by this committee at the October meeting. It was presented to that larger working group that includes Chief Trial Counsel and representatives from the California Judges Association. And that's what you're seeing in blue on your screen right now. So it was tweaks to comment 6 and the new comments 7 and 8. Comment 8 is essentially just part of what used to be in the body of Rule 8.4, now moved to a comment. And then what you'll see below that, starting at line 128 on the screen and in your materials, is there was a lot of conversation about revising the comment to kind of talk about 3 different buckets of activity. And that was something that was prepared just for consideration today.
Right, so we could, yeah, so the main issue was, well, there was, what came about in our discussion, I can't remember all the issues that were raised about our original comment 7, but what came about was that there was, you know, it was more precise in the types of activities that that will subject lawyers to discipline. So there is a statement made with specific intent of producing imminent lawless action against a judge or judicial officer. So that's just the imminent harm standard. And then true threats of violence is the second standard, which, you know, those first 2 are probably pretty rare. And the third element is really what we had originally been more concerned about, and I think what the judges are more concerned about, and frankly, it really presents the free speech issues, and so that's kind of the one that we should focus on more, because it's, you know, it's the one that's a little bit more fraught. So first, I want to see if anybody has any comments or questions about this 3 bucket. I mean, that's how George Cardona phrased it, and so I just picked up on it. But it's, you know, the 3 elements basically that comprise of activities that are not protected by free speech. If you have any comments or questions about that, and then I want to just move to the 3rd bucket. Because I have some alternative language, I think, that I want to propose there. So does anybody have any questions or comments about the change, basically the overall change in the comment? No. Okay. So the opinion that Erica, what's the name of that opinion? Olin, right? I thought that it captured this 3rd element well, but this 3rd element is missing the fact that it's an objective standard. So can I email, or I'll put in the comment maybe a quote from the Olin case that I like better than this. Let me just see here, hold on.
If you put it in the chat, she can add it to the screen for everyone to see. Cassie, just for context, I only shared that opinion. It's a new review department decision of the State Bar Court. I shared it with the working group, so the full committee does not have access to it. We can circulate it, but they just don't have it.
Right. I mean, while I'm doing that, can you just give like a brief synopsis of it? Do you mind? Or do you remember? Am I putting you on the spot?
You're muted, Erica.
I muted myself, apologies. So basically the case is a review department decision. What that means for those of you who are not individuals who practice at attorney discipline is the State Bar has its own court system. It's an administrative court. And the review department is the appellate division, essentially, of the State Bar Court, and can issue published and unpublished decisions. Published decisions are precedential for all of the State Bar Court decisions, and then anything that goes past the level of a reproval and is required to be approved by the California Supreme Court. So that's considered to be actually discipline, and it has to go to the Supreme Court for review. I'm saying that because this is an opinion that was filed on November 26th of this year. So it was issued by the review department, and it's a published decision, but this is not final discipline in this case. So it could still change, essentially. So what happened in the opinion is a few things. It kind of addresses attorney civility as well as judicial threats. But the State Bar Court Review Department issued a 9-month actual suspension, increasing this proposed suspension from what was recommended at the hearing department level to an attorney who sent harassing and abusive emails to several judicial officers, accused judges of accepting bribes, called them corrupt, evil, and lying, used misogynistic language, which is becoming a theme in state bar discipline cases, and also threatened the commissioner's minor child. And what the opinion talked about is it kind of it threaded the needle a lot. So it talked about how certain statements that were made were protected by the First Amendment and other statements that were made were not. And basically what it did is it said that when it becomes harassment or involves credible threats, then that has more limited First Amendment protection and can be the basis of discipline. And then also accusing the judge of factual things. So things that we've discussed kind of when we did the Gagman conversation at our October meeting. So accusing the judge of lying and saying that the judge was bribed were factual issues that did not meet First Amendment protection and could be the basis for discipline. Basically, ultimately, the court found that that was moral turpitude in violation of Business and Professions Code, section 6106.
Wow. Erica, thank you so much. I literally put you on the spot to do basically a book report on this case, and you did it perfectly. So thank you.
To you all now, so I won't give it, but thank you.
Okay, and so Angela put up here this is basically just taken directly from that case. So this isn't the exact language that I would want to substitute in, but I think it's important. The two aspects of this quote that I think are missing from element 3 are that it's an objective standard, and then it also covers rhetorical hyperbole. And it kind of fleshes out more what reckless disregard means. So, I mean, I guess we can kind of wordsmith this here, but I think that we want to say, let's see. I would at least want to say the sentence where it says our First Amendment analysis utilizes an objective standard to determine what a reasonable attorney in light of his or her professional functions would do in the same or similar circumstances. I would want to put that, highlight that, because I thought it was important in the context of this case. The court really did analyze, I think it was in when he accused the judge of lying when he said the judge lied when she said that she had reviewed briefing or something, and the reason why he said that she lied was because she asked a question about a factual issue, and he said that because she asked that question, it means she didn't review the briefing or whatever it was. And the court said, no reasonable lawyer in that situation would think that the judge was lying. And so I thought that was really important because it really does, show how the limitation of free speech, of a free speech defense would play out. And I think that the reasonableness standard is critical, because it's not just, the lawyer saying, well, that's what I believed, or subjective intent. So anyway, I'm asking for some help with wordsmithing. If you guys can jump in or tell me what you think about this kind of alternative language and how we can sort of revise this third element here. Anybody?
Angela, do you?
I can't really.
This text on the same page as other text. We just want to zoom out a little bit so people can see it.
Do you want me to move the whole 7 down so you can see both?
That'd be helpful, I think, for everyone. Thank you. And then you just may need to zoom out on your screen. I'm only able to see comment 7.
Yeah, and I can't really see everybody. Let me see here.
I can handle raised hands if you want, if that's helpful.
Okay. Oh, that's better.
that too small?
No, no, that's good. Oh, that's good too. Just, well, no, go up a little so we can see both the part 3 and then the full paragraph below, starting with additionally. Yeah, I think that's fine for me. I want to put in, where would you fit in rhetorical hyperbole? A false statement of fact. Let's see, false statement of fact. Or statement asserted as opinion, or as rhetorical hyperbole, like for example, or something like this. We'll put a comma there and put or rhetorical hyperbole in quotes, because that's from the Yagman case. And then maybe at the end, let's see.
Saying what is not protected by the First Amendment, but isn't rhetorical hyperbole protected?
Yeah, but we're qualifying it. It says if the rhetorical hyperbole implies actual facts are capable. So, I mean, rhetorical hyperbole is an example of an opinion, right? Or similar to an opinion. But if rhetorical hyperbole implies actual facts that are capable of objective verification that are false, then that's not protected. Or am I not,
But I
am
think,
I reading it?
no, I mean, yeah, I understand what you're saying, but then the next paragraph almost says that if it's defined as hyperbole, it's confusing.
Okay. Wait, the next, which part?
So additionally, statements characterized as rhetorical hyperbole and statements of opinion that are incapable, because what you're saying is if it is capable of being proven, then it's not okay. But if it's not capable, it's not sanctionable unless it can be reasonably understood.
Yeah, I mean, I'm not, this additionally, that's not gonna be, we're gonna delete that once we pull from it.
I see.
You know what I mean? Like, does that make sense? Sorry,
Okay,
I just want to be able to see because I like using the phrase rhetorical hyperbole, because it's taken from the Yagman case, because you can have false statements of fact, you can have opinion and rhetorical hyperbole, and if either of those two things imply facts that are false, then that's not protected. So I just wanted to include the rhetorical hyperbole as an example there. And then at the end, say that implies actual facts that are capable of objective verification that are false, made with knowledge or reckless disregard of the truth or falsity of the facts. So I would want to put this analysis, take this sentence, our First Amendment analysis utilizes an objective standard. Take that sentence and put it at the very end of the comment 7. And then that would just. Oh, no, wait, that should go.
Talking about at the end, total end of the paragraph, like 162.
Yeah, the total, yeah.
Or now 160, yeah.
Yeah, right there.
And then it would be a quote thing.
Well, I don't know, can we quote from that Olin decision? Do we want to quote from that, Erica?
I wouldn't yet.
No, I know. So what I want to do is rephrase it so that because they're using it, they took it from Yagman, at page 1437.
So what about courts? Courts have attempted to use an objective standard to determine what a reasonable attorney would do in similar circumstances. Something like that.
Yeah. I would just say courts utilize an objective standard. So take out our First Amendment analysis and put courts. Yeah, that's good. And then go all the way to what? Oh yeah, to determine what under similar circumstances, or I mean, I like that. Can we do? Can we just
Yeah,
use
well,
that language?
I mean, maybe we can put professional function, something in quotes, or just reword that. It just sounds a little bit like citing without citing. So.
Yeah, I mean, or we can go back to Yagman and see what the exact quote is. Okay. Let me see if I can see here. Does this look, well, okay, while I'm looking up Yagman to find if there's a quote for this principle, Deepika, why don't you talk about the alert? Because what we're doing with this is twofold. If you recall, we're doing the comment, but also we are planning on issuing an alert that Topeka drafted, and I haven't been able to go through it fully. The working group still needs to go through it, but maybe you can do a little preview of what you drafted, Topeka.
Sounds good. And I'll start by saying I believe the idea, Cassidy, please correct me if I'm wrong, the idea behind framing this one as an alert was the time factor of getting this guidance out to the community in light of the physical safety issues discussed in the guidance, but perhaps that's something that needs further discussion. Because I think we've had a helpful conversation today about the difference between alerts and opinions. But either way, I think this guidance is intended to track, or as currently written, it tracks really closely what we're seeing in the red lines to rules 8.2 and 8.4. So it's intended to kind of hew really closely to the proposed rule revisions, rather than introducing too much that's new, and really kind of give a preview of what might happen with these rule amendments. So the alert starts with just some general statistics to kind of frame up the issue of threats against judges and judicial officers, and draws on some guidance from the ABA to set that issue up and why this is important for the committee to be addressing. And then walks through kind of the committee's general guidance that threats against judges, judicial officers that have the effect that's kind of laid out in the edits to the rules that we have here are already prohibited by rules 8.2 and 8.4, but that the committee is considering rule revisions to make that prohibition more clear. And then it walks through rules 8.2 and 8.4, and again, just kind of sticks pretty closely to what we're seeing in these red lines to the rules themselves and the comments, and in particular to frame up the First Amendment analysis that not necessarily, these statements are not necessarily protected by the First Amendment, and then walking through some of the cases that are discussed in the current comment revisions to explain situations where certain either activities or statements weren't protected.
Yeah, and I think that's really important, because I was thinking, I think we should put examples of, where statement, like from the Olin case, calling a judge a liar, or accusing the judge of taking a bribe, or, that sort of thing. But it's probably more appropriate to put in the alert, and so we can just explain all those distinctions in the alert.
I do think we'll need to make a further adjustment based on the language in Olin that we're pulling out now, because if we don't want to cite to that language just yet, if it's not necessarily final, we could instead pivot and use this language that we pulled out from the opinion just now and tie it to Yagman instead.
You mean in the alert? Did you put
That's right.
Olin in the alert? Yeah, I mean, because I just pulled
That
up
might be more
Yagman.
appropriate.
Yeah, and I just pulled up Yagman and this quote, this language is exactly in here, and it's Yagman is actually quoting from Sandlin, a district court decision, United States District Court versus Sandlin, a Ninth Circuit case. So it's an internal quote. So let me see here. So it's it says we held that oh yeah, Yagman is a Ninth Circuit case. So instead we held that such proceedings are governed by an objective standard pursuant to which the court must determine, quote, what a reasonable attorney considered in light of all of his professional functions would do in the same or similar circumstances. So yeah, so put quotes around starting with what? A reasonable attorney. And then that's Yagman at 13, what did I say? It's or 1437, but it's do we have to do like a form and then quoting United States District Court versus Sandlin? Here, I'll put that in the chat. Let's see, 67. Okay. So you would put id is it id at 1437, or do id at 1437 quoting the Sandlin case? Is that how you do the site? I'll leave it to the
We can do that.
yeah. Okay, and then you can delete all of the additionally paragraph. Okay, so that's my proposal. Does anybody have any thoughts, changes, whatever, comments? No?
I just a sort of a drafting note. In after number 3, it says a false statement of fact, comma, or a statement asserted as opinion. Is that
Such, okay, go ahead, sorry. Or rhetorical, go ahead, sorry, I just cut you off, Dan, because I was jumping to my own thought. Go
I
ahead.
think the statement asserted as opinion is disconnected from something. It isn't just a statement asserted as opinion, right? Does it have to be a statement asserted as opinion that implies actual facts that are false?
Yeah.
Okay.
Yeah. So that's confusing. So, yeah, I think we need to kind of, it says a statement asserted as opinion, or a statement asserted as, well, no, that can, let's see.
If you move rhetorical hyperbole, I think to the right after false on the next line on line 157. Would that accomplish it?
But that also, the rhetorical hyperbole also has to imply actual facts. So we need to kind of say opinion and say it as opinion or rhetorical hyperbole. I mean, so asserted as opinion or rhetorical hyperbole that implies I mean, I don't know, that both the implies actual facts qualifies both opinion and rhetorical hyperbole. If you don't put a comma after rhetorical hyperbole.
Such as rhetorical hyperbole.
Well, that's what I was thinking, yeah. Why don't you do opinion, go back, move rhetorical hyperbole back.
Or should it be including rhetorical hyperbole?
Yeah.
Do you want me to move it back or keep it down here?
Move it back. And then just instead of or, put including.
Is it including though? I'm sorry to chime in.
Yeah, what is rhetorical hyperbole? I mean, I think it's a subset of opinion, right? I mean, if rhetorical hyperbole is like, I don't know, like I'm trying to think of that opinion, what did Olin say about some of the things that he said? I mean, things that are so outrageous, but they still, so they can seem like, so outrageous, nobody would believe it. But if it's implying, that the judge took a bribe, for example, then yeah, that would not be protected.
So now I just
So I think it's
need a comma after hyperbole, so it's clear that the following quote also modifies asserted as opinion.
yeah. So put a comma right there. Yeah. I think it goes inside the quote. Including. I mean, I think that's good. Sorry.
Is somebody familiar enough with the case to make sure that that's the holding?
Of Yagman?
Yeah, the rhetorical hyperbole. Because the rhetorical
Her-
hyperbole is one of those areas that's protected speech, right? So how does it fall into this?
Let me look it up. I have Yagman up. Hold on. Okay, it says. Oh. Maybe you're right. It does. Go ahead. So Eric, are you talking?
Well, I thought Yagman said it's always protected because rhetorical hyperbole, I think like by definition is.
It's protected speech, right?
His opinion, it's not fact, it's not factual.
I
Well,
thought
what
that
is,
was
okay.
exaggeration. It's strange. I think maybe it was a remnant or something.
Well, here's the statement. Hold on, I have it. It says thus, okay, even statements that at first blush appear to be factual are protected by the First Amendment if they cannot reasonably be interpreted as stating actual facts about their target. Okay. If they cannot reasonably be interpreted as stating actual facts about their target. Thus, statements of rhetorical hyperbole aren't sanctionable, nor are statements that use language in a loose figurative sense. So it sounds like they're saying that rhetorical hyperbole is an example of any statement that cannot be reasonably interpreted as stating actual facts. So if it's rhetorical hyperbole, by definition, it cannot reasonably be interpreted as saying actual facts.
Yeah.
I don't necessarily like that because it changes my. So I'm glad that you, Eleanor, told us to go back to Yagman. But now I want to go back to Olin because that's not what I think Olin said, which we can't use. But let me go back to see, maybe I misread it. Yeah, okay, so, this is what we deleted. Statements characterized as rhetorical hyperbole and statements of opinion that are incapable of being proven as true or false are not sanctionable unless, so it's grouping opinion and rhetorical hyperbole as together and saying that, unless such statements could reasonably be understood as declaring or implying actual facts which themselves are false. So it's changing what Yagman says.
I think, Yagman, I mean, my understanding of First Amendment law on this would be if it's rhetorical hyperbole, it's protected. And they're
Yeah.
saying, well, while it might look like or be characterized as rhetorical hyperbole, if it's not really rhetorical hyperbole, then it could be sanctionable. That's how I
Yeah.
interpret what you just said.
Okay, let's take out rhetorical hyperbole. Let's not muddy it up. We can just keep opinions in there and then have the objective standard at the end. That satisfies my concerns when I pulled this out of Olin. I think. Yeah. Oh, sorry, Novella and
Yeah. I had a question about the rhetorical hyperbole. Like, I agree with Eleanor how she described the rule generally, but I thought from last time we were saying that, well, like one issue is what is the rule generally, and then another question is, do we think the same First Amendment, like constitutional free speech frameworks, applies to attorneys even when the conduct potentially like prejudices the administration of justice? So from the edit that we just added, I'm hearing us now say that we think there isn't like a different rules for attorneys based on or different analysis. Is that?
I think
Eric, yeah, go ahead.
so far is that in this, like they haven't gone as far as they have in the advertising context, for example, where they have said that lawyers have limited more reduced free speech rights dealing with advertising.
Because commercial, right?
Which they have been clear that it would not withstand, or that it would withstand, excuse me, First Amendment scrutiny.
Right. I mean, so this was the kind of the discussion we had with Cardona, and basically he said, you know, free speech is a defense to the disciplinary action, or an absolute defense, but there are 3 areas where it does not protect, you know, the free speech doesn't extend as far as you know, some lawyers would want. And so he was pretty clear about that. So I don't think, and we wanted to use his guidance because we're talking about, you know, what can be, you know, what works in the disciplinary, when these disciplinary cases are brought. So I think we should stick to what, you know, what's actually been litigated, you know, and determined by the courts as far as comments made by lawyers about judges. And I think even this Olin case, even though it's not final, makes it pretty clear that that's the approach, is you do this First Amendment analysis. Okay. So are we happy, or is there any other questions? Novella, do you have any other questions about the change?
No, that was helpful. Thank you.
Okay. Okay, well, I think I'm happy with this because what we're gonna do now is vote this out, Erica, is that right?
I believe, Topeka, please correct me if I'm wrong, but I believe we said we would share it one more time with CJA. So perhaps January, but recognizing that if we continue this, we will never get to our,
Right.
but
Yeah,
next step. So this is something that would usually go to the Board of Trustees as a recommendation, and we would provide a lot of context and history explaining that it was sent to COPRAC through California Judges Association. It was, you know, a COPRAC working group was formed, and we included numerous conversations with OCTC and CJA, and the committee recommends moving this forward. The only reason that Rule 8.3, for those of you who were part of the committee, had a public comment process within COPRAC itself was because of the timing and deadlines that were provided to the committee. So this would not necessarily follow that same path. This would be something that just goes straight to the board, and then the board would issue it for a public comment more typically, is how this process usually has worked.
okay.
With civility, for example, as well as the CTAP changes to 1.5 and 1.4 and 1.15. So that would be what would happen. So I think we said we committed to sending this to CJA one more time, but do you and Cassidy, do you recall?
That's also
Well, I
my,
know.
oh, sorry, go ahead, please.
No, you go ahead. Take it.
That
Sorry.
was also my recollection that we discussed these 3 buckets, but we hadn't written them up. So chatted about circulating that language for discussion before taking any other kind of further action.
Yeah. Well, and so you only circulated it to me, and then for this committee, for this meeting, we didn't circulate the 3 buckets to the CJA. Okay. Yeah, so let's go ahead and, I didn't realize, I forgot. Okay, so yeah, let's go ahead and circulate it one more time with CJA, and then we will revisit that, and the alert at the next meeting. Oh, Raquel, sorry, I didn't see. You had your hand up?
You just addressed it. We'll talk about the alert next time.
Yeah.
I didn't know how it fit based on what I heard. I heard.
Yeah, the working group has to take a look at it, and make revisions, and then we'll have it ready to go over at the next meeting. Okay, cool. Next, so no other questions on this. Now we're going to the symposium. Erica?
Yeah, so what's left on the agenda is talking about the symposium and then 2025 planning and new opinion topics. I'm recognizing that people may want to finish early, but also recognizing that talking about planning and these types of things is usually not the best thing to do when people are kind of fatigued. So I leave it to the committee to decide if they want to take a quick break, a long break, or no break.
I don't care. Do 2 people want to take a half-hour break? Raise your hand.
How much is left,
No.
Cassidy?
So we got 2, well, we have like basically planning, the symposium planning, and which I don't know, we probably have an hour left or so, maybe. So if we have an hour left, you guys want to just plow through?
I'd vote for like a 5-minute, 10-minute break and then plow through. That's my vote.
How about a
I agree with
10-minute
Eleanor.
break? How about a 10-minute break? It gives us a little bit more time to take a breather. And then we'll come back and finish up.
Perfect.
Cool. 10 minutes.
12:40 is a 13 for even timing. Oh, okay.
Good. Okay. All right.
12:40 if you can still hear us.
I can hear you.
Like we're back in the record.
Back on the record. Yes, thank you. Okay, so now we're gonna do item 4.11, the symposium. And I'll let you take it away, Erica.
Okay, so we have the symposium scheduled for April, as it typically is. Let me pull the exact date unless Angela has it. No, I don't even have it on my calendar yet. So we'll get the date for you in just a moment. But what we would like to do is start talking about topics, as well as individuals who may be interested in serving as moderators for panels. So for our new committee members, the Ethics Symposium is an annual free, more recently free, continuing legal education event for attorneys. Because this committee is an ethics committee, we typically focus on primarily offering programs that provide some sort of ethics credit, but that has kind of shifted a little bit as the sub-credit fields have expanded. So there's 6 hours of required ethics credit, but there's also other credit requirements such as technology and the practice of law, which is a new credit requirement as of the compliance period that will be in 2025. Civility is another new requirement that has a lot of ethics components tied to it. There's a new requirement as well. So, and Angela just said it's on April 18th. Thank you, Ange. So I think that's another thing to discuss as well. And just a little context, we have over the past few years kind of been doing things a little bit differently in the sense that it used to be that only the most senior members of COPRAC were given the opportunity to be panel moderators. That has certainly not been the case in more recent years. If there are too many people who want to be moderators, sometimes we do allow for the more senior members of COPRAC to do so just because they may be terming off sooner and not have that opportunity. But if anyone is interested in serving as a moderator, and if anyone is interested in suggesting a topic, we'd love to hear it. And we can go through kind of past topics over the past couple of years as well, either, to make sure that we're not doing the same thing over and over again, or if you want to kind of think of some ideas. Typically, we start looking for panelists kind of sooner rather than later. We've oftentimes started in January, and it seems to have gone okay. But we could, for now, if anyone has any topics beyond the kind of recent developments, symposium topic that is always the first program at the symposium, we could certainly start talking about it.
Good. Oh, sorry, Raquel, good.
Your mouth was moving first. Go ahead.
Yeah, but you had your hand up first. So
That's okay.
I think you're president. So just because I'm new to this, I want to make sure I understand kind of like the kinds of things that we be discussing. Is it just generally, in anything that sort of touches on the committee's work, or is it kind of even broader than that? And in respect of that, if it's the former, then I'm still very, I'm seeing a lot of rapid development in the area of technology and the law, and in particular, artificial intelligence and other sort of tools that have been released at a pretty rapid clip over the last year. And so I feel like that's something that, might be of interest.
Yeah, I mean, so did we have an AI panel last year? We
We
did.
did.
Yeah.
In the past 2 years, actually, we have had
We
a
have.
so we had one in April of 2023, while the committee was developing the practical guidance that was ultimately issued, and then the 2024 symposium was basically explaining, a large part of it was explaining what was within the practical guidance. That does not mean that we can't, I mean, it's still a hot topic. So that doesn't mean necessarily we can't have it be a topic again, but we have kind of just broad scope provided education on kind of the ethics components related to it with that kind of a focus.
Yeah, I mean, since then, there have been I don't know, probably 5 ethics opinions from different states that have been issued, and there's definitely been more developments. I think it's worthwhile to have an ongoing discussion about it, which I think it makes sense to have another panel, or maybe let me ask Nima this, are there other tech issues that we can group with AI that we can kind of broaden the panel that may be appropriate to talk about as well? Like what else, besides AI, is there anything else?
Yeah, I mean, I think, so I guess it depends on how you define AI. I think there's pretty much everybody's slapping the word AI or the thing on everything that they're doing. But there are sort of iterations of it more recently that I've seen that are interesting to me, and pose some questions even outside of the practice, which automated decision technology is one that comes to mind. And so I know, for example, the California Privacy Board is working on pretty detailed regulations on how that stuff is supposed to work, and that obviously I think impacts a lot of what we do in terms of resolving disputes. And so, anyways, I think there's a short answer. I do think that there are a lot of new kind of applications of the concept that raise interesting questions about how one advocates, but also if you're on the decisional side, whether or not it's appropriate from an ethics standpoint.
Okay, I mean, yeah, I'm in favor of kind of covering all of that because it's so, you know, relevant at this point, and it's going to continue to be relevant. We might as well just stay on top of it. So that's my 2 cents on technology. Okay, let's see, Raquel, and then I don't know who had their hands up after that, but Raquel, go ahead.
Hi, Erica, were you asking us only to comment on recent developments or the entire?
No, so recent developments is typically a standing topic at the symposium. Unless there's a strong desire to eliminate it, I don't know that we necessarily should. I think that's been a standing topic since kind of the beginning of time at the symposium. So I think beyond that, I think we're talking about what else the committee would like to discuss other than so the other 3 topics essentially beyond recent developments.
Okay.
Last year there was some overlap between recent developments because that's when the practical guidance came out and
Right.
also the AI topic. But I think this year it would not hopefully be that. I mean, I think recent development could largely be succession planning at this point. And then everything outside of COPRAC as well. So I'll just say, Nima, to answer your question about what COPRAC talks about, it doesn't have to be just focused on what the committee has been doing. It can just be hot topics that relate to the practice of law with kind of focusing from an ethics perspective.
Okay, thank you for your answer, Erica. I do have some things that I do think should be covered in the recent developments, but I'll say that last. But I think the tech in the practice of law, the area that I do think we should introduce given sort of the current trend we're probably going to see is more in the area of crypto. And so while the committee is I'm not sure what point we are with the work that we're doing. I think whatever we have by April should be introduced into this symposium. And so if AI is something that we want to do, Cassidy, you talked about, is there something that we can expand? And I think crypto could be expanded to talk about in that panel. But I do think, you know, we're going to, with Mr. Musk being the shadow president, we're going to be dealing with a lot of crypto stuff. So I think we as a committee should be proactive in thinking about it and sort of putting some parameters around it. I think last year we did something that was more geared towards a panel that was more specifically geared towards people. I think they called it flying solo. Cassidy, I think Joel did it. And so I think some topics that can fall under that could be helpful. To me, it seems like perhaps this idea of conversion clauses and fees and CTAP, that may be something that fits nicely in that area, particularly as we've talked about the larger firms probably have less of an issue with this because of who their clients are, if they are even involved, that this is more mid-size or individual practitioner. So I'm thinking about not only the topic, but sort of catching the interest of the different demographics of attorneys attending the seminar. So what would be of interest to them? So that's an area. It seems to me something with this in-house counsel, because we've been struggling a lot with it, and it seems like it has a lot of pieces to it, could be something as well. And I don't know what we could do about civility, but it also seems like some reminders around civility, and maybe that's the I just called it violent speech because I'm not sure what it was, but the thing we just talked about. I don't know if that's enough for a whole session, but you know, we just saw this week what happened with the insurance person and lots of other things happening all the time. So I think a reminder, some kind of interactive conversation could be of interest to the broader members. So I'll just stick with I won't, at this point, I said I was gonna introduce it, but I'll come back and maybe, well, I guess I'll say it. I think recent developments, this thing about abortions. And I realize I'm not sure where we ended up with that, but that seems like that probably is also on the minds of our members. I don't know if this idea of immigration sanctuary citizens that also cities may play so similar to abortion. So that seems like a big topic. Maybe the succession planning, since that just got approved. Those are a couple. I'll leave it there. Over. And excuse me, I would like to facilitate a panel, maybe.
Okay. Okay, Mary Grace.
So similar to what Nima was mentioning with regard to AI, like I know in my role, I see it a lot, especially corporations are really cracking down on our outside counsel guidelines with regard to how we use AI. So it's so complex. And I know we're also dealing with issues of oversight because firms are now using it and so it's just, I don't know where we want to go with it. It's huge, but I do think that's, we definitely want to get involved with that. The other thing is if we're going to be issuing this, civility addendum with regard to, violent speech towards judges, I do think that might be a good opportunity. If we release it before the panel, then I think it might make sense to have that be a panel. I'm sure there's going to be lots of questions as to what this all means, how it is going to be implemented, and all the questions and all the things. So
That's I don't know if it's enough for an entire panel, but maybe we can work it into something, but I like that idea, and we can get a judge to speak on the panel. What do you think, Erica?
We will theoretically have civility rules maybe by then. I think we will be more likely to have them by then. So I think it could be kind of an all things civility.
Oh, yeah.
I would certainly recommend well versed in First Amendment issues based on the struggles that we've had in this space as well. So
right. Yeah, I mean, it'd be nice. Well, I mean, can George Cardona, I mean, would he do it, or is he able to do it, or somebody?
If you need a judge, Cassidy, I can get a judge for you on this one for sure.
Yeah, I mean, I think we can get somebody from our committee too, but yeah, I mean, like, I'm sure like Wendy Chang could, well, I'm not gonna say I'm sure, I'm gonna volunteer her without talking to her. But yeah, I mean, I think a judge and somebody from OCTC who has the First Amendment experience, or at least just a First Amendment lawyer, would be very helpful. And then, yeah, I think it's a good idea to group it with the civility rules, and that would be a really good panel. Okay,
I would
so
be more than happy I'd be more happy to moderate it as well. So throw my hat in there.
Great. Okay. I think Emil was next.
Yes. So I guess the thoughts that I have were when we were talking about AI and all that. I'm actually at a conference right now for legal tech. So we have a bunch of legal tech startups, investors, but also small and large law firms that came together. And I think it'd be helpful if you want to broaden the topic of AI. Maybe it's AI mixed with legal tech. And I know that our committee cannot opine on UPL, but maybe this might be a time to, have a conversation about UPL and, potentially legal tech and UPL. So app and AI based practice of law issues, but also anything else about that conversation surrounding UPL. I'm not sure if that's possible, but I think it might be a way for us to just have that conversation and be able to talk about it. And going back to Mary Grace's point, there's a struggle because law firms need to innovate, and there's also the access to justice issue with like I found there was this company here that basically does expungement, which is a kind of it's something that a lot of lawyers don't want to do, but it's something that many people need. And if they can use a service to provide it at a low cost, that would be great. But connecting those dots, figuring out how to do the supervision, how to avoid UPL considerations or risk of robo signing, things like that. I think having a conversation about that, but also at the big firm level, we have outside counsel guidelines that say, you can't waive a conflict of interest, or you cannot use AI unless you're using our LLM, or you're doing something. So it might be helpful to have a mixture of conversations that deal with AI, legal tech, and maybe UPL and other issues related to those topics.
One of the things that's happening a lot is corporations, and I hate the use of, I'm not going to use it, sophisticated clients, because I think that's BS, but is that there's rules around using AI and whether or not it's considered like confidential information. Can you plug in something and use it, and is it actually confidential information, and how you are using it? And then it moves into what I've seen, even as far as like ownership of that information once you've collected it. And so I'm getting into the weeds of it, but I think really making people cognizant of how are you using this information? Where are you plugging it in? Do you have what sorts of technology is it in? Like for some large law firms, we are now having our own like in-house technology that is created for ourselves, which is different than ChatGPT. So I mean, it's a lot to flesh out, but I do think like if we were to bullet point, I don't know, 3 sub pieces that we can cover. And what are they? They're 1.5-hour presentations?
They're typically about 1 hour 15.
So we can divide it into maybe 3 subsections for that and the civility. Then we can cover a lot more ground that way.
Well, civility would be a different panel altogether, but
right,
like AI,
of course. That's what I mean.
AI
is like, it would be a separate panel, but it, to cover, the violent language towards judges topic, and then maybe do 2 other subtopics within civility. So then we have like a more robust civility panel.
Yeah, so go ahead. Sorry, Erica, go ahead.
Your UPL question, this came up last year when we were talking about doing an AI topic, and the symposium can include a component that addresses UPL issues. It's just that the committee, as part of the program itself, can't opine on UPL and those types of things. So we can raise issues and issue spot and address it from that context, but you can't say, yes, this is UPL, and no, this is not. Someone else on the panel. Not co-rep.
Oh, really? So like the moderator can ask questions, and then somebody else can.
I would recommend against it, but it's co-prax restriction. We can go back to the First Amendment conversation, but I don't think we can tell anybody what they can't say at an MCLE program.
Right. I'm also including detailed discussion and within the technology panel, and what email is talking about with the legal tech kind of entrepreneurial growth of all those businesses and whether or not they're engaging in UPL. I think it's a really interesting discussion. I don't know how, I don't know how helpful it is for just your average practitioner who attends the symposium, but I just think it's a cool cutting edge topic that, as ethics attorneys, we deal with, especially if we deal with tech and all that. So I would be for that. Okay, I can't see if anybody else has their hand up. Are there
Carrie,
any other?
Carrie
Sorry.
had-
Oh, Carrie, sorry. Yeah, I don't know why all my,
Oh,
my
I lowered it
pictures.
back down because Mary Grace took the words out of my mouth. And I don't know, I don't know if we've talked more generally about outside counsel guidelines for the smaller like firms and for the solo practitioners at the symposium. Have we like really dived into like how to manage outside counsel guidelines and also like how outside counsel guidelines interact with vendor contracts and have we ever done that before? Because I think we take it for granted at big firms that we have all this like infrastructure to deal with this. And then and it takes up a huge amount of our time and our resources. And then, you know, I was talking to a solo a couple of days ago and I asked him, I was like, how are you dealing with these? And he's like, oh, I just signed them. And I'm like, oh, that's great. That's an excellent approach to it. But I mean, there's like all sorts of really complex GDPR compliance and things that are now getting stuffed into these outside counsel guidelines that I don't know if it would be helpful if we kind of address like how to manage them and how to negotiate them and
Yeah, I think it, sorry, I think,
them.
yeah, I mean, so the question I have is, would that be under the tech panel or because outside counsel guidelines is broader than just dealing with tech and so it would be a kind of its own separate panel, I would think. Because it can be a broad topic. Especially when you are dealing with vendor contracts and that sort of, I mean, that could be more like, say like the business of law type of topic.
Well,
But anyway, yeah, I mean,
like it's like you know, our engagement letters now no longer even matter because it's like client tendered terms of engagement are kind of the law of the land now. And so I don't know, it could be interesting, it could be really insightful and could get a lot of people to attend if they were interested in learning more about how to manage outside counsel guidelines.
well, I wonder if we can do outside counsel guidelines in conjunction with an in-house counsel panel, because you have
Absolutely.
in-house counsel, you know what I mean? Like they're the ones who are drafting those guidelines for their client, the company they work for, and then you've got the outside firms that are dealing with them. So maybe we can kind of touch on both of those, you know, thing, like, I don't know, come up with a topic that bridges both in one panel. I'm just thinking out loud, but I kind of like that.
I like that.
Yeah. Eleanor?
Do we know what the attendee population is like? Or do we have a lot of folks from mid-sized firms and large firms, mid-sized firms? I imagine
that's a good
large
question.
firms aren't dealing with as much of it, but
We don't ask for demographic type data attendees we haven't. I mean, that's a really interesting question as to whether we should ask for it on a voluntary basis as part of the post symposium survey. But we have not. It's just been about the course itself as opposed to the attendees. But that's an excellent thought.
But I know that these issues are affecting small and solos because that's actually who might benefit the most from this, because like the big firms, we have all this infrastructure to deal with this. We have, you know, malpractice providers that are providing robust, you know, guidelines and support in all of this. And, you know, and paying for in-tap subscriptions and all sorts of tools to like manage outside counsel guidelines. Whereas the solos that I know literally like they're doing work for some studio and they get an outside counsel guideline and they're like, sure, I'll just sign this. And they don't even understand like necessarily what they've just, you know, bound themselves to, like enterprise-wide, you know, conflicts representation of all the, you know, anyway, I think that the solos and the small firms could actually benefit the most from the guidance.
Well, and I see Emil's comments, the small firms get outside counsel guidance from startups these days as, yeah,
And the
VCs.
VCs.
So Yeah, so
When
it's,
you should see
so
the VC ones are especially,
Really bad.
they
Right.
are, I mean, you
Yeah,
can
yeah,
tell that
right.
they are
Right.
truly Chat GPT generated.
Right.
There are references
Wow.
to statutes and to things in them that don't even exist. And you're like, this is actually coming straight from Chat GPT. It's really
Yeah.
scary sometimes.
That's scary.
I do think that from the feedback we got on small flying solo panel, which was individuals or small firms, was really positive. And I think it was the first time we, categorized that. People said that they thought that really, the information was really helpful, and the idea of, we're here too. Oftentimes, I guess, maybe some of the things we present they don't feel is as relevant to them. So I do think plucking that out. And if we do, like you said, Cassidy, have inside and outside, if we can somehow figure out how to put that together, I think that would be helpful and could draw in some people from both sides who may not, the bigger firms may not have traditionally come as much, or some of the small ones. I want to say something about the AI, the feedback that we've gotten, and I moderated the panel last year, but from the previous year as well, was that on the forums, was people want more concrete information, so more the use case, so something they can, they kind of are already like, yeah, we know the topic now, so but be a little bit more concrete about what is the education we're giving them. So I would just say that as we're thinking about it. And I think based on the things I've heard here, people are thinking about things more concrete, but I just want to vocalize that that has been the feedback as we've done it twice now.
It does seem like that'll be a natural thing now that it's in every single app that we use. It's embedded in everything. And previously it was sort of conceptual, but now, like Zoom can send you a summary and a transcript or whatever, so there are real world examples. I think it's a great next step.
Okay, Erica.
I'll just echo what Raquel said. So we, the state bar, are doing some continuing legal education on AI, and it's just like it's an issue spotting type ethics focused program right now. And I think people are really looking for, okay, great, they want to know how they can or can't use it, as opposed to just saying, that can't use confidential information and that sort of thing. I don't think that's very helpful necessarily at this point. It sounds like the group has coalesced around 4 topics already, which is fantastic. What we can do, if anyone wants to throw their hat in the ring right now, you certainly can. But what Angela and I can do is we can send out just the confirmed topics. It's recent developments from what I heard: judicial threat, civility, outside and in-house counsel, hybrid, and then some sort of AI tech. If people want to think about that more in the interim, we can just email directly to Angela and I, and we can kind of narrow down topics, and if you're interested in moderating, or we can continue to do that right now as well. But just wanted to make sure to tell you that you don't have to do it right this second unless you feel.
Erica, what were the panels you said?
So recent developments.
Okay.
And then from what I've heard with AI and tech, that had a lot in it. So that would need to be narrowed down. It was, we talked legal tech, UPL, automated decision making. Raquel, I think you raised crypto. I think I'll just say I think authenticating evidence is going to be more and more relevant as well. And I know that I think that federal evidence rules are being looked at. So that could be something to address in this space, as well as like Rule 11 sanctions and that sort of thing. So AI and tech, and then judicial threat, civility, so violent speech, civility.
Okay.
Right, did I miss one, or is that?
That's
Or
3.
the AI, or the in-house, in-house, outside counsel.
So that's the 4th one. Okay.
Yeah.
All right. Thanks.
Yeah, that's good. Okay, so yeah, and if anybody else has thoughts or additional topics, then go ahead and email Erica and Angela with ideas, and then we'll finalize the topics at the next meeting. Is that right?
Yes, I think we will send out a schedule as well, deadlines and timelines and that sort of thing. I think that may also help people, to think about if they have the bandwidth to moderate, as far as recruiting panelists, and that sort of thing as well. So we can send all of that information too.
Okay, and then like, so advertising the symposium is just similar to just sending out, as if you're on the email listserv for the state bar, then you'll get marketing materials for it. But I'm wondering if there's any other ways that we are targeting the groups that we think should, like in-house counsel, in-house lawyers, who are not even aware that the state bar exists. Just kidding, but like trying to get more people to come, basically.
Explore that.
Well, I think you just do that, post it on your LinkedIn and your social media. That's
Right.
obviously one way
Yeah,
to
I mean,
do
we could do our own marketing effort. Yeah, I know.
And I can talk as well. We can explore, it wouldn't address the California licensees, but we have, to be an in-house counsel in California, if you're not a non-licensee, you have to become registered with the state bar. So we could explore distributing a communication to registered in-house counsel.
That's a really good idea, I think.
Also,
Okay.
Erica showed when you were talking about appointments this morning, there was a list of, I don't know, at least 10 or 15 groups of people, groups of entities, I guess, that could be another way.
Yeah.
And I would suggest a more user-friendly, postable invite. So I see we post them, but they're so text heavy, but something that gets the point, but you don't have to read it. You sort of can, yeah. So something that's that's more marketing focused than what we usually post on our social would be helpful.
Also, and we can send you all something if you want to post it yourselves on your.
Okay. Okay, so last item then is the 2025 planning and new opinion topics. So Erica, do you want to?
Sure. So I wanted to kind of set the stage a little bit. So what you received was a lot, for those of you who opened and reviewed this. But I wanted to give you more versus less so that we could kind of have this conversation. I'm hoping this will be the initial conversation, that we can perhaps continue this conversation in January to finalize what I would like to do is if you'll indulge me, is a work plan for this committee. For a little bit of context, most state bar committees are required to do a work plan. And that work plan is actually required to be approved by our board, by the state bar board. That is not currently a requirement for COPRAC. I'll just preview that it could become one perhaps as part of the sub-entity review process that the COPRAC is under, which is not done yet. For those of you who are wondering, because I think it was planned to be done quite some time ago, but it's still in process. And so I wanted to share just very quickly kind of what the work plans typically look like. Sorry, I'm sharing my screen quite a bit today. I apologize, but so you can kind of just take a look at what these typically look like as a sample. And then next time around, after we've kind of discussed here, we will actually post something like this to be approved by the committee, ideally at the January meeting. So this is the committee's chart. For those of you who may not have seen it, it's posted on the State Bar website under the committee. It's just been converted into bullet format here. But it's largely what you guys do on a day-to-day basis. It's to address professional responsibility issues, including through advisory opinions, study and recommend changes to the rules of professional conduct, draft arbitration advisories, and provide outreach and education. So essentially, it's everything that we've done in today's meeting, which is great. What is included here is a component of the State Bar strategic plan. So some of you may remember, I think it was October of 2022, our executive director came to a presentation at one of our meetings and talked about the State Bar strategic plan and went through them. And goal 3, just for those of you, this is posted and it's linked here, but we can distribute this as well, is goal 3 is basically where COPRAC is focused, and that's to protect the public by regulation of the legal profession, excuse me. And what that includes is really the State Bar transformed itself into going back to doing a bit more proactive regulation, which is CTAP is a component of that, but so is education. And that's really, I think, what COPRAC is focused on quite a bit, is education through ethics opinions, perhaps through articles, and then obviously through continuing legal education as well. And that's what my office, the Office of Professional Competence, that's what most of what we do is. So, you know, the ethics hotline is really proactive in helping people address ethics issues, ideally before they act. We have the lawyer assistance program within our office, and it does that as well to help people with substance use and mental health issues. And then we do most of the education content on behalf of the State Bar, so e-learning education and other things. So what this may look like if you to develop is taking a look at possible advisory ethics opinion topics that we want to move forward with. Any arbitration advisories, we can certainly put the things that are pending into this as well. Education and outreach, and then anything that's relevant to operations and management, deciding what should be a hotline article and what should be an ethics opinion, I think really fits quite well within this, and that could be a goal for the committee for 2025. So as we discuss possible things to accomplish in this year, I'll be taking notes. I just wanted you to see kind of the format that this will likely come in, so you have an idea. And then we can talk about the things that were posted. And what those were basically 3 buckets of things. So one is the existing opinion inventory that we have, and that shows all of the opinions that are in process or opinions that we have said that we are going to take on. Anything that says it's in the outline phase has not actually had any work done on it. So the committee may want to consider whether or not to continue to take up that as a topic, or if that's as much of a priority for the committee at this time as it might have been with other committee members in the past who probably proposed it themselves. Another thing that's listed or that's posted as part of the materials is a inventory of all COPRAC opinions since the beginning of COPRAC. So what has not been done was when the 2018 rules were adopted, there was no review of the opinions to go back and update rule numbers, because the numbering changed from the California version to the ABA version in 2018. And so our ethics hotline staff did that. And I'll just publicly thank them very much. This was a ton of work for them to do. And what they did is they went through every COPRAC opinion and they examined that opinion and looked at the opinion itself and evaluated whether or not it just required changing the rule numbers within the opinion, or if it would require something more substantive to change the opinion. So that's that very long document that's in a table format and then in a more narrative format. What I think makes sense is anything that says that it's just the rule numbers that needs to be changed, or something that could be done by staff with adding just an editor's note at the top and saying, you know, this opinion was adopted under the prior rules. Please see the current versions of the rules. So you get into 7.1, 7.2, so forth. Maybe something that makes sense here. But the committee may want to consider whether those opinions that mean more than that are things that are worthy of consideration right now. The credit card opinion is probably the best example of that, where some of the opinion, there is an editor's note on that opinion, just so you all know, but that some of that opinion is actually inaccurate at this point because of the changes to the rules to Rule 1.15. And then the final thing is the new opinion topics that we have received. I'm sorry, there's another thing there, and that includes requests from the ethics hotline for opinion topics. So they're on the phone every day with attorneys, and they've come up with a list of things that they think are needed by at least by the licensees that contact the ethics hotline where there's maybe not a clear-cut opinion or case that they can provide, or it could be helpful to have a new opinion. Some of those may be great for articles in the future. And then finally, the last thing that was posted is the new opinion topics requests. There are 3 new ones within there, new-ish ones. One is 4.2, which we had discussed in the past, and there was a recommendation to kind of do more analysis as to whether this is an ethics question or a preemption question. I'd say it's closer to a preemption question. There's a request for an opinion on Rule 8.3, and then there's a request to clarify whether or not certain funds that are held asset forfeiture funds, excuse me, are funds that need to be considered to be trust funds that are held in a client trust account for purposes of CTAP reporting. And that's kind of what I alluded to this morning, that their expert witness, there's a lot of questions surrounding CTAP as to what is required to be put in a trust account at this point, because it's not just, it raises more than it used to based on the CTAP requirements. That was a lot. Kind of jump in where the committee may see fit. I can try and guide the conversation a little bit more, but I just wanted you to kind of understand all of the things that were posted and the basis for posting them.
Okay, so I'm sorry, I'm just looking at the opinion requests. I mean, are we in a position to entertain new opinions right now based on what we have in the pipeline? I mean, do we have capacity to start new opinions? Does anybody have a burning desire to start a new opinion?
I think we do.
Dan?
I think it would be a good idea to do some new ones, just because we have some that are just very old that we're about to finish. And I think it would be helpful to have even new members just go from start to finish.
Yeah. I mean, I think that's a
Hopefully it
good
can be
idea.
done in your 4 years on co-product.
Right, I mean, like, I mean, just, to give a little bit of history on the in-house opinion, that was my first opinion, and it started out as an outline with Dina, and I forget who else was on it. So that was a very, very early opinion that I've, been working on forever. But
Finally answered the question definitively of whether 1.8 applies.
yes, it's been years.
But you got it.
Yeah. So any of the new members, if you have any interest in any of the topics that are here, or you have, something that's not even on any of these opinion requests, let us know. I mean, does anybody have any thoughts now? Carrie, I mean, Nima, you just joined, so. But if Novella, if you guys have any ideas, so, and Topeka, it's a fairly new group here. So if you guys have any ideas, please, pipe up.
I'm happy to work on anything that folks think is worth working on. I think it's kind of my voice is really going now. So yeah, I mean, I would say I haven't had time to really kind of like really think through each of these and to think like what might be the most impactful. So I don't want to like sort of speak out of turn, but I am very happy to take the lead on drafting a new opinion.
Okay.
Maybe it makes sense if everybody just look at this and sort of formulate something by the next meeting that they think could be interesting. It's much easier to work on this if you're really interested in the topic. And some of these could be put together in certain ways and done as an opinion that covers multiple of these questions. So maybe study this and we'll talk about it again.
And
and they start out. Oh, go ahead. Sorry.
I'm no, sorry. I was just to be clear, the one that because I see a lot of materials, but the one that I'm looking at is the 412 new opinion topics 12/6/24 meeting document? Or is there another document I should be looking at?
Nima, are you in the share?
What was that?
Yeah, can you tell us what we're looking at? Because I think we have like 3 different documents with similar
Yeah,
titles.
so the one that says opinion request for consideration at present and title, it's dated 12/06 meeting open session. It was the last one that Angela sent.
Yeah, so that is just for help, that's the 3rd attachment. Depending on how you all access this information, it may be in different places. So if
Right.
you through the public meeting agenda, which is available just by accessing it through the State Bar's website. And if you want to share it, that's the new
Yeah,
request.
okay.
That would be helpful. And so this is an inventory of things that have come through over time. It starts a table and it starts with number, requester date, issue, disposition. Is that what you're looking at, Nima?
Yeah.
And so as you'll see, there are a few on here that either say hold, meaning that the committee decided to kind of hold off on doing anything on these. Or they decided to nothing. And then the ones that are highlighted, those are the new opinion requests. So those are the new ones that have come in since we last discussed this, essentially. I can start with number 2 at the very top, just to give you a brief update. At a prior meeting, I want to say the May meeting, but please don't hold me to that. The committee spent a fair amount of time discussing this. There was an issues document that was distributed at one point. And what has happened is the original requesting organization that made this request is working with a California member of, I believe, the Assembly, who is developing draft legislation to address this issue after this committee kind of looked through the issues and thought that perhaps a statutory change was more appropriate based on kind of the lay of the land.
Yeah, that makes sense.
Told that that is forthcoming. And we should probably be seeing that language perhaps by our January meeting. But that's why that one is on hold, just so you have a little more context.
Oh, like mediation confidentiality, yeah. Okay. So we're not going to go through each one of these, are we, though? Or do we want to?
I think it's the will of the, I think every time we bring this up, we say next time, I will just say. So if it is next time, I would love for it to really be next time. But we can, I mean, staff can recommendations. I think I will just say, if the committee has not, other than the 3 new requests that came in, if the committee has not taken it up in the past, it may not be something that's that exciting to the committee. I will just say we get a ton of questions about the what's required to be in a trust fund and not in a trust fund under Rule 1.15. So to the extent that is interesting to anyone as it relates to asset forfeiture, but also going back to the issues outlined that already exist regarding expert witnesses. And if it was an opinion that maybe is just like, what are funds that belong in a trust account? I think that with some very different practice area examples, I think that would be very valuable to licensees. At least the ones we talked.
Okay.
The ones we talked.
Okay, well, I'm doing that one, right? So why don't I take the lead on incorporating or broadening that outline to include the asset forfeiture question, like what goes in the trust fund and what doesn't go, you know. What? Who, Bill, did somebody speak up or say something? No, okay.
No.
No, okay. So that can be a new opinion, and that can be on the docket for a new opinion. And we can, I don't even know if we have a working group for that one already. It's on the list.
So you're proposing to merge it with, the retainers and fees, that'd be 22-0001.
The expert witness one.
Correct. So that's you and Brandon currently.
Oh, okay. I'll just work on the outline, see what I can get put together to broaden it, and then we can get a working group together at the next meeting. Excuse me. And then, you know, I'm looking here, go back. I don't know if anybody else finds this interesting or exciting, but number 104 about privilege and in the context of trustees. I always get this question, so curious if anybody else is interested in that opinion. Maybe not, but I don't want to take on another opinion right now, so.
Raquel has.
Okay.
Raquel has her hand up. It's hard to see because of the screen share.
Oh, sorry. Go ahead, Raquel.
I can come after you're done, Cassidy. So
I'm done. I'm just.
My
yeah,
hand
go
is
ahead.
not, my hand is not up related to what you were just speaking about.
No, it's okay. Well, I don't know if any of us are really up to going through every single one of these. We have one thing on the agenda or one thing accomplished, which is the 1.15 opinion that I will take the lead on. But other than that, I don't know if we really want to go through each one of these, which I know, Erica, that we should at some point. But maybe we should block out more time at another meeting.
Maybe at the beginning of the meeting.
I think at the beginning,
Right,
that's an important
that's what I
point.
was thinking, like the first half of the meeting will be just on opinion, new opinions and, making assignments and just like tackling it. And then the rest will be, other stuff. Yeah, let's do that. Okay, so Raquel.
I was thinking what you said. I mean, I think we should review it. I think we should do it earlier in the meeting and really be decisive about the things that are on here. We just have too many things on here. So if we're not gonna do it, then I think we should just say, what is it? Agree to not opine, decline to opine. Because we have too many things. And I do think we should use what Erica started with at the beginning as a primary frame, which is the goals of the bar. So I don't necessarily, it's like, well, what we like and what we think. It's like our work is on behalf of something larger than our interests, but what the bar is trying to do. So I think that's the first, that's the first screen in terms of the things that are on here. And then there was one other thing, which escaped me now, but that should be enough. Over.
Well, and let's have, I'm gonna give a homework assignment, for everybody to come to the next meeting with 2 or 3 ideas from this list. So that we're not just tackling it cold. Does that make sense? Does that?
Yeah.
Okay, I've got several hands up. Eleanor, go.
I think the homework idea is a good idea. I was also wondering if we all do our homework on these, what if we did a poll? Like, could we do this electronically where we poll it and then narrow this list down to like the top 10, top 5, and then we can discuss those in the next meeting?
Can we do that, Erica? Can we do like an electronic poll among all of us? Is that feasible and legal for us to do that?
We can do it in the sense that if you guys want to send them to us and we could aggregate them and have that ready for the next meeting, I think that would work.
And then you can, and prioritize, so if we all pick number 102, then that would be like a priority. Yeah.
Right.
Okay, so put that in I guess the to-do list. Like we need to have like a deadline to provide your, opinion, your preferred opinions or topics to Angela and Erica.
And I'll just add, we can remind you, we can reference back to what you should look at, but you also look at the topics. We didn't put them into this document. We can. I'll just say, if there's anything else that we can do to make this more helpful, I recognize this is a lot of material to look at. So if there's anything that on the staff end that would be helpful, if it's just resharing like the only 2 things you need to look at for this homework assignment. I see a few people smiling and nodding, so I'm guessing that's a yes. So we can certainly do that if that would be helpful. And what we could do is we can just, I think the document was just shown that table who requested it, so we can just say ethics hotline, for example, and we can put that as a part of that single document.
Yeah, I mean, just send the link, I mean, you just, right? Just so that whatever email you send, we can just go straight to what we need to look at.
We can do that would be helpful for that process.
Say that again. Sorry, you're kind of breaking up.
Help this. I really will streamline so there's fewer documents to look at. But is there anything else that would be helpful?
Not that I can think of it. What does anybody else have any ideas? I mean, so it's what we're looking at now is the opinion request for consideration at present, and then there's where I lost my other document. Oh, I have to go back. And then there's ethics opinion review, which is everything which is the old opinions. What's it? So COPRAC proposed opinions.
If you'd be looking at, again, if you're following the agenda, is 4.12A and 4.12B.
Right, those are the 2 things. Yeah.
If you want to see our existing inventory, 4.12C is also helpful if you're trying to reference what we have versus what is being proposed. And so 4.12C is just our existing inventory and who is working on things and the status of those opinions.
I don't have 4.12C.
And can you want to see it? Sorry.
Or is it attached?
There you go.
I mean, we saw you.
Yeah.
Oh, okay. Okay. But we really just want the opinion requests and so 4.12A and B, basically what we should be looking at, right?
If you're curious about what we currently have, maybe perhaps for the newer members who aren't on any of these, they can look at what is currently in the queue, so to speak. So just a reminder that anything that's outlined, there actually is not an issues outline on it. It's something that should either be worked on, or perhaps we should decide to not move forward on.
Okay, so does everybody understand what they need to do for their homework? Yes,
Do we have
okay.
a cap on how many we can pick?
No, but
No.
From 2019 still. I will say the committee's made a lot of progress this past year. There's been, I mean, if you think about, I've only been with the committee about what, I don't even know. A while, but not that long. And a lot's been done. So they had a lot of projects that were directed by the Board of Trustees. So this included looking at the Client Trust Account Protection Program, proposing new rules of professional conduct, the civility rule that was directed to be examined, Rule 8.3, the AI guidance. So there's a lot of stuff that has not been, frankly, opinion work that has been asked of this committee that this committee has done. And so I don't want to take away from all of that work. That's perhaps why some of these are a little older than many of us would like, is because there has been a lot of other work done by this committee in the meantime. So, but that's why you are seeing that the 19 is 2019 and 20 is 2020 and so forth next to them.
Okay, so, but as far as the cap, we would want, say, two or three, right? That we want everybody to communicate to Erica and Angela. I mean, we don't want to, we want to be focused. So 2's fine, 3's fine. Anything more than that is probably too cumbersome.
What if we gave them a rating? Like, I'm wondering if it's going to be more helpful if we just give them all a rating for you, like a 1 to 5 or something like that, and then you can give them.
Yeah,
you can kind of
your top 2 and do 1, 2, 3 as your ranking. That would be very
there
helpful.
you go. Yeah, a ranking like that. Okay, perfect.
Okay. Okay. Is anything else on this topic? No.
For the 1, 2, 3 ranking, is 1 yes? Like, which end of the spectrum is?
Desired, but we'll send instructions as well, just in case this isn't retained by the time we send this homework assignment. But we'll send instructions. But yeah, let's plan for 1, 2, 3, and number 1 is the one you have the most interest in. So I can't remember who said it earlier this morning. Cassidy, I think it might have been you, but that means that you could get volunteered for it.
Okay. Okay, well, I think that's it, right? We're kind of losing our stamina anyway. Okay, so everybody has their homework assignments, and have a wonderful holiday and new year, and we will see all of you in 2025. Can't believe it. Halfway through the decade.
Happy
Okay.
Yeah.
The roaring
Yeah.
20s.
Yes, for the roaring. Yes, scary 20s. Okay.
All right.
Bye, you
Happy
guys.
holidays,
Thank
everybody.
you. Have a good weekend. Bye.
Eric,